number 41 to 47.
Yes.
The consent of the petitioners have been obtained, Lordship. The records were directed to be produced. So we need 10 days more time to produce the records. Lordship.
There is a suo motu contempt also.
Lordship, that is also connected.
This show cause has been filed or not?
Actually, Mr. Dinath is appearing in the matter.
No, has this alleged contemner filed the show cause?
Yes,
reply? That has been filed.
that has.
41 to?
41 to 47.
Yes.
My lord, no problem, my lord. Interim is there, my lord, to be continued.
Okay. On the prayer of MSMDB Learned Council for the respondents,
For the state respondent.
for the state respondents, matter is adjourned by 10 days
Lordship.
to enable.
3 weeks, my lord.
Huh?
10 days, 3 weeks.
Adjourned by 3 weeks to enable production of the records.
Lord.
Full stop para. Interim order operating passed earlier stands extended till the next date of listing. 41 to 47.
41 to 40.
Okay.
Applied.
May I please? Lordship, I'd like to mention for listing this interlocutory application for implement of party. Your Lordship.
When have you filed?
It's already been numbered. Your Lordship.
When did you file?
Uh,
It has not been listed.
not listed.
Okay. When do you want?
Tuesday, Your Lordship.
Do you know what is it?
Obliged.
Appearing for listing
Listing what?
for orders,
Matter of which year? Why do you need for orders?
23.
23. What is the matter about?
Metal lordship, regarding compensation lordship, my wholesale stock was paid for and the stock was duly insured by the company.
For compensation.
Compensation.
When was it last listed? We don't think this is a matter for,
Company lord.
not for mentioning. No, sorry. Yes.
May I
next.
please, Your Lordship? I beg to mention item number 9 of the list, my lord.
Yes.
Getting my lord. I am appearing on behalf of Mr. Emrat, my lord.
Yes.
Can it after 2 week, my lord? Actually, Mr. My senior is out of station, my lord. I have
Have
taken
you
the
taken the
Yes,
counsel
my
to the
lordship,
other side?
yes.
the respondent, your lordship.
I'm for a writ
You're
petitioner,
for
my
the
lord.
writ petitioner.
And I'm for a writ petitioner.
Respondent, your lordship. He is for the writ petitioner.
Okay. You have filed the application for vacating.
Yes,
state.
your lordship. I
Okay.
have filed.
A prayer has been made on behalf of Sri M. Nas Learned Council for the opposite party writ petitioner for adjournment. Full stop. When do you want?
Lordship on 13th of
As agreed to by the parties, list on 13th of December. As agreed to by the Learned Council for the party. Para, interim order passed earlier to continue till the next date of listing. Okay.
I have like to.
Lordship, I beg to mention a contempt case for listing. Actually, it has been complied. So if it comes up for it can be.
Monday.
Lordship, item number 65, admission matter. Lordship.
Yes.
Lordship, your Lordship has extensively heard this matter. Lordship, I am praying for if this matter can be updated, Lordship, after the motion matter.
65.
This matter was fixed yesterday. It did not talk.
Is it part heard?
Yeah. Part heard, not Lordship, but it has been brought back.
We'll see. Let us see first. There are many matters.
After the motion
Admission.
matter, Lordship.
Let us see. Oh, we'll consider. Okay.
Wait, please, Lordship. I'd like to mention for listing of an urgent matter, my lord. On Monday, it's a tender matter.
Motion.
Motion, yes.
Okay. Motion, no problem. Monday.
Obliged.
Your Lordship, Lordship, I beg to mention item number 20 and 21, Lordship.
2021. Yes.
Lordship, I am appearing on behalf of AK Gupta, Lordship. And the matter may passport for the consent taken, Lordship.
2021. Your behalf on behalf of
AK Gupta, respondent number 5, Lordship.
the names are not shown.
Recently, 5 local number.
How much time do you want?
2 weeks, Lordship.
It is submitted that Sri A.K. Gupta Learned Council has entered appearance for the SP number 4.
5.
SP number 5. Whose name, however, has not been shown in the cause list. Full stop. Para. He is as prayed for on his behalf. List this after
2 weeks, Lordship.
after 2 weeks.
Lordship, in this matter, interim is there.
2 weeks. Para. Interim order passed early to continue till the next date of listing. Okay.
Obliged.
Item 1.
Well, this is application on 11/6.
One, this matter perhaps will not like to take.
My lord.
Will not like to take up this matter.
Okay. The earlier bench also did not take it up. my
Oh,
lord.
no, there's between the same parties, this court was involved as a
Madam.
council.
My lord,
Maybe some
may I
other
bring, my
matter.
lord, because it may be listed next week, my lord.
Okay, not list before any other bench without me. Since urgency has been expressed, matter may be listed in the next week.
Matter election matter non-payment of matter. Admitted bill amount, my lord, 5%.
Which department?
Transport department.
Transport department.
No, matter. Home department.
Yes. Where is the acknowledgement?
Matter this page 16, matter.
60,
16.
16.
The bill was matter, submitted, forwarded by Superintendent of Police to matter, Assistant Inspector of General Execution.
How much is the amount?
48,72,793.
How many vehicles?
8 vehicles.
Part 3A Khaniker Learned Council for the petitioner who has approved this court for a direction for release of contractual bills amounting to rupees 48,72,793 for hiring 8 numbers of vehicles of the petitioner by the Home Department, full stop. The Learned Council, by referring to the communication dated 1/11/2023 within bracket Annexure B, has submitted that the amount in question is an admitted one. Full stop para. Let notice be issued, returnable by 4 weeks. Sri Bokolial Learned State Council accepts notice on behalf of all the respondents. All the respondents. Extra copies, huh? Right, Monday.
Developed.
Please, your lordship, this matter relates to non-payment of the supplier's admitted final bill, lordship. Amount of
Admitted, where is the admission? Let us see.
admitted also, so I have filed an RTI, annexure 5, page number 120. So reply is given as the annexure 6,
Page.
page 121 last page. So reply is that reply of this RTI regarding the non-payment of this bill dated 19/7/2020. So here is the mention is the with reference to the subject matter, I am to inform you that as the required fund was not sanctioned from the concerned authority against the implemented scheme for which payment could not be released to the suppliers as shown below. So amount of rupees 1 crore.
Your S.
15.
Chakraborty. S. Chakraborty.
Yes, sir.
Heard MS Chakraborty Learned Council for the petitioner. Okay, huh? In the Agriculture Department, amount of rupees
1 crore 15 lakh
1,
96.
15,
9.
96,095 for works done with the Agriculture Department.
Lordship, respondent number 2, I am not happy. Only
We are yet to issue notice. Let us see. Issue notice, returnable by 4 weeks. MS Bora. Learned Standing Council, Agriculture Department.
Yes, sir.
Accepts notice on behalf of respondent number 1.
Lordship, yes.
I think Bokolial can accept for Director Chora Diaz.
sorry, definitely.
RS Devi is there. One standing council from the
She is the standing council. Serve a copy upon her. Whereas MS RS Deori, Learned Standing Council for 2 extra copies on Monday. Madhu hiring charge Nelekiba. Agar vehicle cycle Nelekiba.
Hello, guys. Much of it.
Item for here, my lord, I am a fair price license shop holder, my lord. My license was put under suspension on 15/6/2023, my lord. Then I,
15/6.
15/6/2020.
Okay, you filed an appeal.
My lord, no, I file a, my lord, they issued me a show cause notice. I filed reply there to my lord.
Okay.
There is no response, nothing. In the meantime, my lord, the 90 days statutory period was over, my lord. So my license was supposed to be revoked. They did not do it, my lord. So I approached this honorable court, my lord. Then that my lord will find in the course of the hearing, they produced a cancellation letter before this honorable court. Then the honorable court said, you are given a liberty to assail this order of cancellation before this honorable court again. That is why I am before my lord, by virtue of the leave granted
Oh,
by
now,
this honorable court.
now the license itself has been
Cancel.
cancelled.
Now I'll take my lordship to the cancellation order, my lord. That my lord will
Okay.
find at page
63.
64, my lord. It is
64.
translated, my lord. Now, my lord, suspension order was issued against the 5%, and it was disposed of by a common order, my lord. There is no specific allegation against each of them, my lord.
What is your name?
My name was, my lord, last two,
Maman
Maman Kormakar and Sadhan Chasha. They are the petitioners before my lord.
Okay.
If your lordship kindly have a look into the order, why there show cause notice to all 5 retailers were issued by so and so for filing their returns representation in I filed return in presentation. Now, my lord, all the 5 cases are taken together. What are the record they relied upon? What are the specific allegation against or this is by common order. They, my lord, painted the same person with the same brush. It's a very cryptic order, my lord.
Yes, Mr. Bokolial.
My lord, this order is available before the deputy committee.
By virtue of the leave granted
My
by
lord,
the.
as per clause 29
I
B
know,
of
my
the Assam.
Appealable.
Yes, my
Cancellation order.
my lord.
Yes, what do you say then?
My lord, we have granted a leave by this honorable court. Lordship
No,
may
my lord.
kindly.
Leave her.
Yes, yes. My lord will kindly see that start from page 61, 62, 62, my lord, may kindly see. Mr. Chetia, learned government advocate, has produced a copy
Okay.
of the order.
We wish
under-
to notice, but this order, per se, does not appear to be a very reasonable quantity of reasons. It's a very kind of cryptic kind of an order.
Yeah.
There's no discussion. What are the charges even?
Yes. What are the finding vis-a-vis the petition and
You have
another?
not said anything.
My lord.
Have you seen the order?
Yes.
There is some narration. What are the charges? That even that is not there.
Nothing.
Heard Sri B.J. Ghosh, learned counsel for the petitioners, within bracket 2 numbers, who has put to challenge an order dated 6/11,
Yes, my lord.
6/11/2023, issued by the SDO Civil, Lakhipur, Kachar, whereby their fair price license have been cancelled. Full stop. Para. Sri Mokolial, the London State Council, however, submits that there is a forum to prefer an appeal against such an order. Full stop. Para. In response thereto, Sri Ghosh, the Learned Counsel for the petitioners, has submitted that while in the earlier round of litigation, in which the subject matter of challenge was the order of suspension, this court, while closing, decided writ petition WPC
WPC, my lord.
6412 of 2023, wide order dated 17/11/2023, had given liberty to the petitioner to assail the order of cancellation, and therefore the objection would not be sustainable.
Otherwise,
Full
my
stop.
lord,
Para.
my
That notice be issued. This aspect of this matter would also be considered. Full stop. Let notice be issued. We'll fix a date.
Right.
You get the records. We don't think this is sustainable.
Yes,
You-
my lord.
My lord.
returnable on the act, but difficult. hardly we have got time till the vacation. We'll go to the next year. Can we have it on 3rd? 3rd of January,
Part of the-
reopening day, I think. 2 তারিখ বন্ধ আছে নাকি এবার? খোলা দিছে তো?
My lord, may I submit my lord? Can it be after my lord the view because I have a medical treatment. my
Okay,
lord,
no
operation of
problem.
my eyes,
If you have a personal difficulty, we'll have it after.
my lord's operation of my my lord.
Okay, tell us returnable on
My lord, after view vacation, any date
on
after. I'll
19th,
be-
19th of
Yes, my lord, yes, my lord.
19th of January.
My lord, I have a prayer for
Oh.
interim. My lord, or my lord,
Cancellation.
my lord, they may be
No, we're saying something else.
restrained from initiating fresh process.
What fresh process?
For
It's
granting
very-
license respect of that shop to any other person, my lord. That is of course.
কি করলো? 91. 3. Bukolia Leland State Council accept notice on behalf of all the respondents. Let extra copies of the writ petition be served upon him by Monday. Full stop. Para 3. Ghosh the learned counsel for the petitioners praise for an interim order. Full stop. Para considering that the impugned order is an order of cancellation, comma, no blanket order of stay can be passed. Full stop. However, comma, it is observed that any further action taken in this regard would be subject to the outcome of this writ petition.
My lord had called for a record.
Yes, we'll call for the record. So and so accepts notice. The learned standing council may also procure the connected records.
Apply for.
বন্ধ করেছে 1 or 2 দুইটার দুইদিন বন্ধ হচ্ছে আসলে প্রেস and this it was এটা এখানে লিখে দিয়েছেন ঠিক আছে bro দেখো তো yes
Mr. Lordship, the matter pertains to settlement of Parghat, Boitagori Anchalik Panchayat of Bongaigaon District, Your Lordship. Your Lordship, initially, Your Lordship, NIT was issued on 26/5/2023. I came out as the highest bidder. Verbally, I was asked to conduct the business of the Parghat. Your Lordship, being satisfied that the earlier year, in the earlier year also, Your Lordship, no formal order was passed. I was conducting the Parghat, Your Lordship, the businesses of the Parghat, but on 31/8/2020.
What is the difference between your bid and the bid of the respondent number 7?
Your Lordship.
How much is the difference?
Yes, so Lordship, it is around, Your Lordship will, if Your Lordship move on to page 27, my bid amount was 2,11,000 and
He had
respondent
given 151.
151. Yes, Your Lordship.
Why to the second bidder?
Lordship, I hear earnest money was 66,667, but the petitioner deposited the amount only 60,000. So it's less than the earnest money.
Oh, yes, you did not deposit the earnest money amount.
Your Lordship, I have deposited the earnest money amount, Your Lordship, but now please saying that I have deposited 60,000, not 66,000.
Your I Hussein,
Yes, Your Lord.
Heard Sri I Hussein, learned counsel for the petitioner. Full stop. It is the case of the petitioner that pursuant to a notice inviting tender dated 26/5/2023 for settlements of various bazaar, ghats, min mahal, the petitioner had offered his bid with regard to the Oudubi Khaluapara Parghat under the Boitamari Anchalik Panchayat in the district of Bongaigaon. Full stop. It is the case of the petitioner that since his bid was the highest, he was verbally allowed to run the Parghat, which he was doing. Full stop. The grievance of the petitioner is, however, with regard to an order dated 4/11/2023, whereby the respondent number 7 has been offered the settlement. Full stop. It is the specific case of the petitioner that the bid of the respondent number 7 is less than the bid of the petitioner, which was the highest. Full stop para. MS J. Bora, learned N. Bora, learned Standing Council PNRD, however, submits that the bid of the petitioner was defective in view of the fact that the earnest money which was required to be deposited was not done in the manner prescribed. Full stop para. Settlement for 1 year.
Yes, your lordship.
Okay, we'll fix the date. Let notice be issued, returnable on 3rd of January.
Lordship, if your lordship peruse the comparative statement, your lordship,
No, if there is a defect, then we cannot do anything.
even your lordship, the bid of Saidul Islam, your lordship, he has not submitted any documents, your lordship. The comparative statement suggests that, your lordship. Yes,
Page.
case 27, your lordship.
Yes.
Yes, your
What is
lordship,
your name?
My name is Rafinul Islam.
Your Rafiqul.
Rafinul.
Rafinul. And
He is Saidul Islam.
Saidul is R7.
Yes, your lordship. Saidul 7, R7. Your lordship, he has not submitted financial sound certificate, Jama Mandi copy, land valuation certificate. So your
Yes, well, how have you done?
and no remarks, nothing is there in the remark column also, your lordship.
You have also not deposited anything.
Yes, your lordship, but my humble submission is that, your lordship, in the later state, I have submitted all these documents, your lordship.
You have also not deposited anything. You have not deposited anything at all. Returnable so and so. MS Bora, for whom? 1, 2,
For
1,
for respondent number, I am 1, 2, 4, 5, 6.
1, 2, 4, 5, 6. Here for 3. Extra copies by Monday. Steps by registered posted ready for respond number 7. Full stop. On the next date, fixed comma. The Land Standing Council will also procure the records and an endeavor will be made to dispose of
Your
this
lordship,
petition.
still returnable that in the interim, if the order may be suspended.
We'll try to dispose of this matter. We'll see the records.
All right.
I can say it's like
May please, your lordship, matter may be taken at two, lordship, Mr. B. Sodri lacks in another person.
What is the matter about?
My lord, the tender matter, my lord, two particular words, each could be similar type, but very cleverly put particular type. Similar type is a word prescribed by the rules, my lord. That word has
What
been-
is your grievance?
my grievance is that, my lord, kindly see page 33,
3-3.
33.
Yes.
This is page 33. This is a parallel rate contract of agro-plastic items, my lord. Agro-plastic items means a one category of items, agro-plastic items, and date is 29/7/2023. And my lord, kindly come to page 38 of the tender.
Yes.
38, my lord, kindly see. Roman
Page 38.
Yes, 38 of the tender.
Yes.
Roman 2. This is the part of the tender, my lord.
Open competitive bidding.
Bidding method shall be followed for selection of most preferred bidder for the tenders item. The tender terms, conditions, and procedures are in conformity with the Assam Public Procurement Act 2017 and Assam Public Procurement Rules 2020 as amended from time to time.
Yes.
My lord, this is the grave violation of this clause, my lord. This is my case, my lord.
What is the violation?
My lord, for that, my lord, kindly come to page 135.
135.
No, 135.
Yes.
This is the Assam Public Procurement Act operative part.
Yes.
135.
Yes.
My lord, D.
Yes.
Tier number D.
Pre-qualification bid stage.
Bid stage, competent qualified bidder shall be shortlisted by using measurably pre-qualification criteria like past experience of similar contract, my lord.
Yes.
The similar contract, my lord. Here, one more important.
Now, what is the violation?
My lord, violation is this. Only one more point, my lord. In Here, my lord, it has been stated at page 133.
133.
133.
Yes.
First Roman 2. Roman 2.
Yes.
First line, second line. I'm reading the fourth line, my lord.
Yes.
Standard provisions in the standard bid documents shall be used without any alteration.
Yes.
And this standard bid documents is also accepted by the government. And this standard bid documents, the word similar type is used. Here I have enclosed it, but they have deviated to this, my lord. My lord, come to page 68.
So what is the prejudice you are suffering or caused to you?
My lord, kindly come to page 68, my lord.
68.
68.
Yes.
Here, 4.2 qualification criteria. 4.2.1 required minimum experience, my lord. Here, kindly see the bidder, if not the manufacturer of the goods offered, should have experience in supply of at least 20% quantity as specified against a particular item, my lord. This is the deviation, my lord. I am a bidder, my lord. I have experience of similar type, but people like us were type to be eliminated from.
Now, what is the violation in writing with a particular item? If
But-
your experience is sought for 20% of the quantity
Right.
of a particular item, what does it violate?
particular item, the word use this similar item
Where?
in the procurement rules,
Let us see.
page
Again,
35.
135.
135.
Yes.
Roman 2.
Yes.
In the pre-qualification, the bid stage, competent qualified bidders shall be shortlisted by using measurable pre-qualification criteria like past experience of similar contracts.
Yes.
Similar contract, my lord.
This is similar content. These are different items.
My lord,
These are different items.
not different item, my lord. They have followed these rules, my lord. This tender is
No,
issued-
see, if you come to the chart at page 68,
Yes, my lord.
the items, these are all items are different of huge quantities. You
But-
may have experience in some, you may not have experience in the other.
My lord, these are 25 items, all agro-plastic items, my lord. All agro-plastic items, not different type. These are all agro-plastic items. And this is in the tender, my lord. I will come to that. My lord, there is a protest.
Okay,
Huge-
then let Mr. Chaudhary come.
Well-
Once.
At 2, my lord.
At 2 o'clock. Okay, 2 o'clock.
My,
Or maybe if Mr. Chaudhary comes after a while.
my lord,
Last motion.
my lord, I'm waiting. I'm waiting.
Wait, your lordship. The matter relates to marking of the voter of the petitioner lordship, in spite of his father, father being declared as a Indian citizen by the tribunal lordship. And upon approaching the respondent authorities by a letter dated 2/8/2003, SP Vishwanath, to the election officer Vishwanath, page 31, Annexure G, lordship.
Can you come directly to the writ court? The voter. Mr. Gogoi?
Who's the tribunal?
Is it not required to be adjudicated by the tribunal?
Lordship, but SP has to send the reference to the tribunal. Here, SP is sitting over the matter, lordship. In this regard,
Have you written to the SP for a reference?
lordship, I have
See,
written.
your father is declared as an Indian citizen.
Lordship.
That may be a relevant factor, but that is not the conclusion of the matter that
Lordship,
you automatically become. You have to have a link between your father that you are his son.
lordship,
That is your contention, but
Lordship.
you have to prove.
lordship,
Now, once D has come,
lordship,
the onus is shifted upon you. Now there has to be a reference.
lordship.
He
Kindly-
has only approached the election officer. Only election officer he has approached. As per the annexure.
You take instructions
Lord,
on Friday next.
Lord.
Okay.
Lord.
Third pre-Bordello Learned Council for the petitioner petitioner, full stop. It is the case of the petitioner that though his father has been declared as an Indian citizen in a reference
lordship,
by the which tribunal? By the
lordship,
Foreigners Tribunal,
lordship,
Sutia.
page 17, lordship.
Sutia. Furnace Tribunal what? Vishwanath?
Sonitpur Tezpur Lordship.
Well, Furnace Tribunal, Sonitpur, Tezpur, comma. The petitioners has been termed as a devoter.
Lordship.
Full stop. Para. 3. K. Gogoi, learned edition, senior government advocate Assam, however, submits that the present approach of the petitioner may not be the correct approach, as there is an adjudicating mechanism.
May I submit? Lord?
No, we're giving him time.
Lord.
Para, let instructions be taken on this regard. No, on the prayer of the Learned State Council, list this matter on Friday next date, enabling him.
Indicate whether reference is made.
To enabling him to obtain the instructions. Full stop. Such instructions may also include regarding any reference.
Lordship, may I submit one thing?
Yes, yes.
Lordship, in Annexure G, it is clearly reflected that during verification of existing records, Register of SP Office Border Branch and FT Court of Vishwanath District, no case reference is found initiated or pending against the petitioner.
Yes, you take, let an extra copy be served upon
Lord.
during the course of the day. Give it today itself. Let him-
Lord. Oblige you. Lordship for motion.
Motion.
Oblige you, Lordship.
May I please your lordship? The petitioner before your lordships have completed their DPharm course from different institutions. After that, there is a mandatory provision for internship. They have done the internship. After that, they have applied for the license of pharmacist. Some of them applied nearly 1 year ago, but till now, the lordship, their licenses has not been issued. Reasons based registration. The registration.
Well, the Assam Pharmacy Council is non-functional as on date because of some legal issue which is pending. Similar matter came up in court number 6 today. It has been fixed on my lord Tuesday. So I pray this matter may be taken up on Friday next week, my lord. Whatever is the outcome, I will convey it on Friday.
Your D. Sharma.
D. Sharma.
Heard Sri D. Sharma, learned counsel for the petitioners. Full stop. The petitioners, who are 40 in numbers, are aggrieved by the inaction of the respondent authorities in granting registration of their application, they're granting registration as pharmacist. Pharmacist. Full stop. Para Sri B. Gogoi, learned standing counsel, Health and Family Welfare Department, however, submits that a similar matter is fixed on 6th.
No, it is fixed on my lord 5th.
On 5th of December. Full stop. He accordingly prays for adjourning this matter. Full stop. Para. List for motion again on 8th December. Full stop. An extra copy of the petition may be served upon him during the course of the day.
Oblige your lord.
Item 16 supplementary.
May I please the lordship? The lordship, this is a transfer, my lord. Lordship, see page 50, my lord. Please the transfer order, my lord.
50.
50, my lord. Smita Roy, my lord, she was transferred from Kamrup Metro to District Barpeta on 28th.
You work as what?
District Program Officer, man.
Under the?
Under the National Health Mission, Assam, man.
50.
50, man. This transfer order was issued on 28/10/2022, man.
Just a minute.
Last year, my lord.
28/10/2022. 2020. What happened? Transferred from?
My lord. Then, my lord, we
transferred from where?
My lord, from Kamrup to Barpeta, my lord.
From Kamrup
to Barpeta. That is
Barpeta.
That transfer was made within 2 years of my joining from Bangaigaon, my lord. Now, my lord, we challenge this order at page 56, my lord.
56.
56, my lord. Operative portion, my lord.
You are a district program manager.
Manager.
You filed 7107.
Sir, yes, ma'am. This is my lord, order dated 7/11/2002.
What happened?
That lordship may see the 58 page, my lord, after hearing letter counsel for the parties. 58, my lord, last parties and taking into consideration the representation made on 1/11/2002, still pending disposal for mission director NHM. Respondent number 2 in this petition is disposed, directing the respondent to consider the representation dated 1/11/2002 made by the petitioner within a period of 2 weeks. While considering the representation made by the petitioner, respondent number 2 shall also take consideration of our medical problem as well as transfer policy
Yes.
of NRA. Now, my lord, the page 61, my lordship may see that this representation rejected, my lord, by speaking order at page 61, my lord.
61.
Yes, page 61, my lord. They have constituted a medical board, my lord. Actually, my lord, the brief fact is that, my lord, she is, my lord, getting that IVF treatment, my lord. She is 40 years of age, my lord.
Mitra Roy.
She's- That accordingly, the representation 1/11 submitted by Ms. Smita Roy requesting to stay her transfer liable to be rejection, and she is transferred to NHM Barpeta District Sonapur.
Okay.
Then, my lord, again, we approach this court, my lord. Lordship may say page 79, my lord.
79.
79.
Okay. What happened?
This court, my lord, interfered with it, my lord. Page 79 is the matter. Actually, by this order, my lord, page 80, my lord. By this order, the court asks us to give the medical record to the counsel for the other side. We handed over entire medical record
Which
to
is the order?
page 80, my lord.
80.
We have submitted the entire medical record to the counsel, my lord, who took 3-4 days time and seen the records and came back, my lord. Then lordship page 82 order, my lord. 81 is the starting.
Yes.
82 is the order, my lord, 19/12/2002. Lordship is para 3, my lord. From para 3, my lord. The petitioner has produced certain medical documents to indicate that he had lost her pregnancy at 11 weeks of gestation, and as such, she has been advised to undergo further specialized treatment for her fertility issue. In the course of such treatment, the certain process has been already been done.
Reconsider.
Yes, my lord.
Direction
Then-
for reconsideration.
Yes.
Thereafter,
Thereafter, my lord, it was considered page 87, my lord. No, page 80.
this 7. 10 November.
This now this order is passed. Now I'm attached to it at Guwahati, my lord. I'm getting my treatment. Now, while getting my treatment, just at the verge of 3 years, my lord, this impingement order is passed. May I read this order, my lord?
Yes.
So carefully gone through the record of WPC number so and so, filed by the petitioner, Ms. Srimati Smita Roy, District Program Manager, who was transferred from Kamrup Metro to Barpeta by 28/10/20. Writ petition was disposed of with a direction to pass speaking order on the representation of the petitioner. In the course of the petitioner's medical treatment, matter was referred to medical board, and while examination finding opinion that she is high risk for further treatment for pregnancy because of her advanced stage of 40 years and declining to fertility and previous 3 pregnancy loss, there should not be any adverse effect on the health of the condition of Smita Roy for joining in a new place of posting Barpeta. Speaking order was passed, keeping her transfer order in abeyance. She filed second writ petition and Honorable High Court directed to dispose of her representation, passing a reason order. It appeared from the records that Ms. Smita Roy, except her representation, didn't file any other relevant documents, doctor's prescription, medicine, purchasing receipt, etc. support of her petition. Very carefully consider the representation Smita Roy and heard her personally. Normal transfer is due course in condition of service. She has been kept serving for more than 3 years in the present post. Her transfer order to Barpeta was kept in abeyance earlier, considering her representation allowing to complete her IVF treatment course now stands vacated, and she is attached in the same capacity against Barpeta. This I have not understood, my lord. Is attached with Barpeta in the state headquarters NHM office of Certain Guwahati until further orders, and in the resultant vacancy of Kamrup Metro as incumbent as per order dated 28/10/22. shall join accordingly considering the urgency of the district program activities of the Kamrup Metro District. If it is Kamrup Metro District, my lord, then he should be attached here. Ms. Smita Roy shall accordingly report for her duties with her representation, therefore stands disposed of accordingly.
Yes.
Now, she is in, it seems, my lord, either Guwahati or Barpeta, my lord, this is not clear, my lord, but she has been released from her post, my lord, Barpeta. Now, my lord, she is undergoing treatment, my lord. It takes some time because I have annexed the documents to lordship, page 63 may be seen, my lord.
But this has been taken care of by the officer,
No, my lord.
and the opinion has also been taken that you are at a high risk for further treatment of pregnancy.
That is earlier, my lord. Then we have come to court because of that, my lord. Lordship may see 63, my lord.
No, you come to the fourth paragraph of page 87. See, file this.
See in the picture, that's it?
No, see, page 87, fourth paragraph.
Fourth paragraph.
She filed second writ petition.
Yes, she filed the second.
High Court directed to dispose of her representation passing reason. It appears from the orders that so and so except her representation did not file any other documents.
My lord, we have, that is earlier order, lordship. See, the entire document has been given, that order, my lord. I have shown to your lordship. Page 79, my lord.
79.
Yes. 80 may be seen, my lord. A Bora learned counsel for the respondents in the health department is allowed to inspect the medical reports of the petitioner to form a view as to whether a treatment of the petitioner is undergoing. If is of such a nature that it bring it to a logical end, it required to be continued at the same place at Guwahati where it wasn't going on. I have bunch of documents which I produced before them, my lord. Now this is absolutely, my lord, incorrect statement, my lord.
Where are you undergoing treatment?
In Guwahati, my lord. There is only one, this is Guwahati, that IV treatment. It cannot be held in Barpeta, anywhere in Assam.
No, where is it going on?
Indira, madam.
Huh?
I have annexed, my lord, page, lordship may see page 71.
Where in Guwahati?
Pratiksha, huh? Pratiksha and Indira, my lord.
Indira is where?
Indira is in, that is page 71, my lord. It is Ulubare, Guwahati, my lord.
Now you are released.
No, release, but I have been released, which I received yesterday only.
Today is 1st of December. Order is of 10th of November.
Yes. No, I released, but just yesterday I got a copy, my lord. The copy.
Yes, madam.
May I please, Your Lordship? The order dated 19/12/2022 of this Honorable Court Finder,
Yes.
page number 83,
Yes.
last part, my lord,
Yes.
that if the treatment undergone by the petitioner requires her to be posted at Guwahati for furthering her treatment, necessary accommodation be made for the purpose.
Yes.
And she has been attached in Guwahati, my lord, not in Barpeta, my lord. She has been transferred now, my lord.
But why, if she is attached at Guwahati, why is she released then?
Not that post, my lord. Earlier she was in district, my lord, district office, and now she is in state headquarters, my lord.
Then it's okay, my lord. Then I have no
She
objection, my
in
lord.
Guwahati and
Madam, you take, are you making the submission on instruction?
Yes.
You have got the instructions, then there is nothing to be worried.
telephonic instruction.
Madam, I have the written instructions. I think you may be mistaken. But we'll do something. We'll protect your interest till the next date. We'll give next Wednesday or Friday. You have the instructions properly. You set the motion still. Don't take such a risk. Because the impugned order appears that Barpeta has also been mentioned.
Yes.
It is not very clear. If
Not
you
very
make it clear that
Earlier she was transferred to Barpeta, now she is attached in the state headquarters, my lord, within Guwahati, my lord. So she
I also
can-
find that, my lord, there is some, let her take proper inspection, but otherwise the order is, some ways.
okay, where is that part where from where you are posting it, Guwahati itself can be discernible? Can be discerned? Which one?
That is, my lord. That is page, my lord, 50, my lord.
You, earlier you were where?
I were in Bangladesh to, I've transferred to
No,
Guwahati.
no,
my
no, no.
lord.
Here in Guwahati, where were you?
Guwahati in, my lord, this thing,
District of-
only one
District-
place, my lord.
District Program Manager.
My lord,
Where was the posting?
Guwahati, my lord.
No, no, where, which office?
Under joint director, my lord.
Now you have been transferred to
He
uh,
addressed in the same capacity.
to the NHM headquarters. I think it's clear, I think. We can dispose this off. And we record her statement. Heard, Sri J. Roy, Learned Senior Counsel for the petitioner.
Lordship, there is some, my lord, because the lordship may issue notice, my lord. Because
No, you are in Guwahati itself, in the headquarters.
no, there is no post in Guwahati, my lord.
No, that they'll take care of.
No, they have to take away that's all, my lord, because there is
Okay,
no
well,
post in the
Okay, well, on Wednesday.
on Wednesday.
Full stop. Though an order dated 10/11/2023 has been put to challenge pertaining to the transfer of the petitioner, there the learned counsel submits that there is some confusion in the order as regard to the present place of posting of the petitioner. Full stop para. MS A. Bora, the standing council NHM, however, submits that taking into consideration the cause espoused by the petitioner pertaining to her treatment, pertaining to her ongoing treatment, the petitioner has been retained at Guwahati itself and is presently attached,
State headquarters.
posted at the state headquarters of the NHM office. Full stop para. Sri Roy, the London Senior Counsel for the petitioner, however, submits that as per instructions, there is no vacant post in the state headquarters. Full stop para. Let this matter be listed for motion again on Wednesday next, enabling MS Bora, the London Standing Council, to obtain instructions in this regard. Full stop para. Depending on the instructions received, an endeavor would be made to dispose of this writ petition.
No course of action till that matter.
No?
No course of action or.
What course of action?
Well, I've been reading.
Nothing, only 3 or 4 days. That nothing is going to happen.
May I please, your lordship?
What is this?
This pertains to, my lord, non-payment of outstanding contractual use, my lord, of water resource department, my lord. My lord, the work order were given in peace.
Where is the admission?
My lord,
Where is the admission?
admission is, my lord, is page 54 to 55, my lord. Completion certificate.
Heard 3 SR Rabha Learned Counsel for the petitioner, who by means of this application has prayed for a direction for release of contractual bills amounting to rupees 31,62,083 done with the Public Health Engineering Department. Water Resource Department, full stop. It is contended by the Learned Counsel that the amount is admitted, and in this connection, Annexure 8 of the writ petition has been referred to. Full stop para. Let notice be issued, returnable by 4 weeks. MS J. Gogoi, Learned Standing Counsel, Water Resource Department, accepts notice on behalf of respondents 1,
1, 2,
2,
4, 5,
4,
and 7.
4, 5,
6.
6, and 7. Whereas B. Gogoi is the Standing Counsel Finance Department for respondent 3. Extra copy.
One more prayer, my lord.
Extra copies by Monday.
One more prayer, my lord. My lord, annexure 2 series, my lord, page 37 and 38. So this annexure was inadvertently wrongly inserted, my lord. This may be kindly allowed.
You have to file IA.
rectified.
You have to file IA.
Obligation. Obligation.
Yes. Extra copies question, eh? Furnish extra copies to them by Monday. Oh, it was a B. Chaudhary, isn't he? Mr. Chaudhary has come, Agriculture Department. No, motion it also, no? Mr. Chaudhary is not there. B. Chaudhary? Mr. Nayak?
Some other comes from the agriculture department.
No, he will be appearing. Then we'll take care of it at 2 o'clock. You don't want to do it. Huh? Upgrade to it, yeah. Dimlal look material. Yeah, Billy got a bohias. Dimlal. Is the petitioner informed about upgrading?
I told them, huh?
Hey, to bohias, better make malar.
Yes, their presence is required for. We are re-informing them, Lord. We have
Okay.
informed.
I'll just wait for a while, then we'll
Yes.
take
Yes.
on the matter.
Yes, Lord.
To file an application for vacating expiry interim order, they file an objection to that today, my lord.
62. Yes.
I have filed a objection against the interim.
Is it on record?
No, today I.
Have the records, then we'll have it.
On
when-
Wednesday or
Wednesday.
Monday.
It is submitted that an objection has been filed to this IA, which is not tagged with the records. Full stop.
Yeah.
Para. List this case on Wednesday will be 6th of December, along with the objection that has been stated to be filed. Para interim order passed earlier, stands extended till the next date of the district.
Apply.
Hmm. 60. 63 and 58.
My lord, this is application, my lord. Vacating application filed by us, my lord, for.
Other side
Other side is not there, my
MK
lord.
Sharma, J. Deka,
No.
who come up for the first time.
First time. my lord.
What
But
issue?
there is an order, my lord, passed by the court, lordship may see, my lord.
In the IA. You have annexed that order in the IA.
IA.
Which page?
Lordship may see page 37. Page 37, my lord, page 43 may be seen, my lord.
Many petitioners are there.
This is a tower matter, my lord.
1610 order.
16/10/2023.
Yes.
Lordship may see last para 7. The petitioners, page
Yes.
46, my lord.
Yes.
The petitioners in paragraph 25 of this writ petition have averred that installation work was say tower is placed, ground-based mobile tower is complete. It has not yet started functioning. In view of such specific averments, by the petitioners that the ground-based mobile tower has not yet started functioning. It is provided in the interim that till the returnable date, the respondent shall not take any
Yes.
further steps also.
Mm.
So my tower has been managed. The lordship may see my next page, page 47, my lord.
Mm.
My license, my lord. I've got the license from Deputy Commissioner Sibsagar District, my lord, with regard to the tower installation of tower. Page 48, my lord, the permission is granted on the following terms and conditions. Now, this are the terms and conditions.
Mm.
Now, lordship may see page
Now, has
40
it, did it start functioning?
functioning, my lord. I'm showing that. Page
Let's
73.
show that directly.
Yes, page 73, my lord.
73, yes.
Yes. Lordship may see on the left-hand side, date of commissioning.
Date of
Commissioning, my lord.
left-hand side where?
Yeah, on the same document on top, upper side, my lord. Address, site ID, name,
Date of commissioning, yes.
date, 12 June to the, this is a commercial commissioning tower. 12 June 23, my lord. Now, they have made absolutely false statement, and lordship may see down below. We hereby confirm that above
Oh.
site,
Who is this Sudip Mazumdar?
is our employee, my lord.
This is your,
We have to send this.
you have generated, is there
yes.
any official
No,
document?
we have to send this document to the DOT, my lord. Department of Telecommunication.
Any acknowledgement
Yes,
by them?
yes, but this is one of the guidelines, lordship message, because
No, no.
nowadays,
This is your document.
yes,
Your document will not make any difference. Your statement, your documents is the same. Is there any document from the authorities acknowledging the fact that you have started commissioning?
we are functioning, but actually, my lord, this is nowadays digital, my lord, this thing, because that's everything is on portal, my lord. They have their own portal, they'll open in their portal. I show
No.
the guidelines, my lord, for a
No,
moment.
show us any printout from the, from which it can be discerned that they have acknowledged the date of operation. This is your document.
He is my document, my lord.
Your document, you make a
But this is
statement, it will not
submitted
make.
before DOT, my lord.
No, that is okay. That's your submission.
Lordship may just see the guidelines, my lord, by which we have complied with the guidelines, my lord.
Mr. Roy, we are not doubting what you are saying. Whether you make a statement, whether you file a document, it is an action from your part. We want to see anything from their part, either acknowledging the receipt of this document or more than that, the date of functioning, commissioning, they have acknowledged anywhere. Either it will be a question of your words versus their words, whom to believe. Is there any official statement?
But yes, we have made a statement, my lord.
No, official statement.
There's official statement out there.
Then we have to take the views of the, whom do you write to? DOT.
DOT, my lord.
You have to take the views of DOT.
Put a expectation. We have to think.
70? That is why we had asked, who is this Sudip Mazumdar? He is your employee.
Lordship may see, the DTC had disposed this order, page 77 of the writ, my lord.
77.
77.
What order?
That is a DTC as District Telecom Authority. And
Yes.
even though our lordship knows that DTC, there will be an appeal before the STC, not to come to this court, my lord.
Yes,
On the last para, my lord,
yes.
on the basis of the fact, it was decided that the application submitted by Kedarnath, Pathak and others, so-and-so, ward number 10 of Sibsagar may be rejected. But that is the complaint made. The Deputy Commissioner Sibsagar also submitted a write-up
See,
letter to the Director of
the
Telecom.
grounds of filing the petition was something different. There will be radiation.
Yes, they have
Now,
managed that.
the
There.
interim order is on a different footing, that
Yes.
if you have not commissioned, don't commission. You have said that
Yes.
you have already commissioned.
Yes,
That is your version. We
Yes.
want to know whether your version is correct by records. Anything, who will verify this part?
this part, my lord, this is because of the login, my lord,
No, who will verify this part?
DOT, my,
DOT is a party here.
DOT is, DOT is not a party.
DOT will be represented by the CGC.
CGC,
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 Central Government Council.
government, my lord, DOT has to be.
DOT will be CGC only. We'll ask the CGC to have instructions, have this on Wednesday. If it is received, then we vacate the order.
This is self-certified order. That's why I'm seeing the guideline. Lordship is just for the see for the guidelines, my lord. I've given the guidelines, my lord. Lordship, see next page.
We have accepted what you have said, Mr. Roy.
Because
We
this
just
is-
want to have their views. Because the interim order
Because-
is conditioned on the fact that they had made a statement that it is not
Yes,
functioning. You are
yes.
saying that we have functioned.
Yes.
There's a dispute of facts. We will just have the confirmation from the DOT. If your application was there, then we vacate
Lordship,
the
take
order.
it 2 o'clock. I'll try to get some, my lord.
If you can get, and by the time you inform the council also.
I'll inform the
Okay, we'll at 2 o'clock.
at 2 o'clock.
You can have this. Anyone that has come, Mr. Sekya?
Lord. He has come. And he will be here also. He just went outside, but he has come. And he has taken the consent from his senior also.
Oh.
I have come. Yeah.
Mr. Gautam, we'll hear the learned AG and you can make notes. We'll accommodate Mr. Chaudhary, but we'd like to proceed with this matter.
I would like to finish my
Yes,
part, Lord,
yes, yes.
before the blessings. So the other day, Lordship, I have placed the writ petition and made some of my arguments on the basis of the record they have placed. And when the writ petition was filed, Lordship, we raised an objection that they have annexed the memorandum.
This
of-
matter will take some time. Other councils can come after at least half an hour minimum. Have some coffee or tea. Not anything else. Do it's a Friday.
So, Lordship, when the writ petition was filed, we made a mention that they have annexed one document that is MOU, Memorandum of Understanding. And when we raised that they have not annexed the deed of agreement, so subsequently there is a direction from this honorable court and they supplied that vital document in the form of an additional affidavit. That Lordship will kindly take the additional affidavit where certain provisions clauses I would like to place.
It starts at 6:31.
Page
6:31.
135.
6:31, I think. Additional affidavit by?
Additional affidavit by the writ petitioner.
Okay, 135, right.
135. Additional affidavit enacting agreement 6/6/2020 in compliance of the order dated
Correct.
10/2/2023.
135.
Yes. So MOU they have already supplied earlier,
Where
but
is it?
now the deed of agreement.
Page
Page 139. It starts.
139.
Lordship will kindly mark the date 6th of June 2020. Two vital dates. One is that in the month of November, the MOU was signed, November 2021.
139.
Sorry, 19.
139.
And
What is the date of the deed? 6th of June.
6th of June
6/6/2020.
2020. And 5/5/2020, the amendment came.
Oh, FAR increase.
FAR amendment
5/5.
2020. And when they have executed this deed of agreement on 6th of June, they were well aware that there is a change of the law. From this document, I would like to highlight that part. Now, Lordship will kindly come to page 142. So the first party is Magmolar and the other party is Protect. So page 142. And whereas the construction was going on, Lordship will kindly come
Yes.
to 1, 2, 3, 4, fourth subpara,
At 142.
page 142.
Yes.
And whereas the construction was going on the project, but by lapse of time due to some serious financial problems and other problems, further construction activities of the project was stalled. Then coming to the next paragraph, in such an unexpected preposition and circumstances, further booking of flats units were stopped as some major rumor already spread in the market, which resulted in irregular repayment of several installments
against the project loan account with NetP, and the said account was slowly turning into an NPA. Coming further, whereas the meantime, due to delay in executing the project, the already obtained permission has expired. As such, the first party once again renewed the permission on 17/5/2017. At that point of time, the FIR he got was 175. Next paragraph. And whereas in order to regularize the gap between the documents and the regularizing the loan account, the first party has executed phase MOU with existing landowners and has also obtained phase power of attorney from them or from their legal heirs. As such, getting new agreement and POA registered, the first party revised the permission and by memo dated so and so, para regulation so and so on 26/8/2000.
First party is the petitioner.
First party is the
Petitioner.
yes, petitioner, McMullen. So till that moment, Lordship, these are the recitals of the situation prior to November 2019. Then coming to the subsequent, not subsequent, one paragraph thereafter. And whereas as indicated above, and the problem in which the first party has now landed into, the first party was not able to come out or cope up with the management of the project, as well as not able to arrange finances so as to continue with the construction project and repay the installment and regularize the loan account with NetP. Since in order to regularize the loan account, NetP was asking for a substantial sum against already defaulted installment, which in the given circumstances, the first party was not able to manage. Then thereafter two paragraphs. And whereas after several rounds of discussion and negotiations between both the parties, that a MOU was signed by both the parties and second party and notarized by dated 15th November 2019, wherein it was broadly decided as follows, that the first party shall transfer and assign all its development rights along with substituted power of attorney, etc., in favor of the second party. Coming to the next page, Lordship, after Roman 4. And whereas the first party thus offered the second party to take over the entire project and carry out further development work by making further investment to complete the project over the scheduled compact plot of land, which include land owned by the first party, which the second party accepted to do subject to certain terms and conditions. Now coming to the last paragraph of that page, 144. Whereas the first party and second party had further sittings and on detailed study, found that the existing master plan layout was not making the project feasible due to the present trend and buying behavior requirements of the prospective allottees. Accordingly, it was found that in order to make the project viable and in order to successfully complete the project, necessary changes in the master plan layout was needed. So they themselves agreed that there should be a huge structural change in the project. So this they have signed. There was no coercion, Lordship. Next paragraph. And whereas the first party being updated on the requirement of law as contemplated under FERA and other related acts and rules governing the project, and finding understanding that the ultimate liability to complete the project or getting it completed through someone else rests on the first party, irrespective of the assignment of the project, and the second party, and knowing it fully well, accepted the suggestion made by the second party, and in order to bring to the requirement of FERA applicable to the project, obtain written consent without force or coercion from 2/3 of the allottees of the project, namely McMullen City Center Residency, so as to give proper effect to the transfer assignment as well as change modification of the project to second party, so as to enable the second party to lawfully take over the project, commence the development of the project by bringing changes in the master plan layout, specifications and other related issues of the project, keeping the whole process transparent and conducive. So they are agreeing for all changes. Then coming to next page, the middle portion, Lordship, page 146, third. And whereas this is very important, Lordship. And whereas the first and the second party, in order to maintain transparency and between themselves, had jointly conducted a survey of the project and had got it vetted to an official technical consultant, namely SPA Consultants Kolkata, and on such joint inspection, the said technical consultant had prepared a detailed report considering various aspects of the existing structures, positions, constructions, quality, etc. So this was done jointly. Now they cannot come and submit before this honorable court that in a foundation of 11-story or 9-story, we are this particular firm, the private party is constructing 21-story. So everything was done and all the inspection regarding existing structures, position, construction quality, everything was assessed jointly. And the report is also part of this MOU, Memorandum of Agreement. Page 147, second paragraph, serial number 3. This time skipping because this is nothing against any other party, but those are not very relevant for the purpose of this litigation. Serial clause number 3 in page 147, second
Just a
paragraph.
minute.
That both the parties, that is first and second party, have entered into this agreement being competent to do so with free will, consent, and lawful object. So will was there, free, consent, and lawful object to achieve and for lawful consideration enumerated here in below, and the object is hereby expressly but not declared to be void. Roman 3, clause 4, Roman 3. The incomplete project shall mean and include the incomplete multi-story construction of residential building under the name of McMullen City Center Residency, commenced by first party over the consolidated and contiguous land, more fully described as compact plot of scheduled land, status of which, as on date, is inspected, duly verified and laid down in a report submitted by Pioneer Geomatics Engineering Private Limited, Kolkata, appointed to SPA Consultants, Kolkata, and the same is made part of this agreement as Annexure 1. Going further, next page 148, serial number 6. The first party agrees covenants and permits the second party to take over the entire project, carry out further development work with changes in plans and layouts, and by making further investment in order to complete the project over the compact plot of land measuring 13 bighas 4 lachas, which include the land owned by the third party. So everything he has done, which is free will. Now he cannot say that the construction is erroneous or construction is weak. Coming to paragraph 9, same page, that in further compliance of the requirement of the agreed terms between parties, the second party agrees to pay a non-refundable amount of 11 crores as cash consideration along with 35% of FAR area as per present permission taken by first party dated 3/11/2018. Now the FAR is 200 here. So 35% of 200 FAR, one party is getting. That is 1,31,443 square feet, or saleable area of 1,75,300, etc. square feet. Together with one attached parking parklet anywhere in the parking attached to such place falling under the first party as area consideration against the transfer and takeover of the entire project on being assigned together with development rights to freshly carry out. Lordship will kindly mark this note. Freshly carry out the construction over the scheduled compact land, which includes the land owned by the first party. Thereafter, in next page, detailed payments made or agreed to made by the second party for and on behalf of the first party. Outstanding loan amount 18.550 crores. B, 5 lakhs as contingency amount liable and towards landowners, flat units, allottees, purchasers, etc. Third is monthly 4 lakhs rupees referred to as monthly deposit to the first party. And next page 150 after this. So 3 payments were made or supposed to be made. One is 18 lakhs one time, then 5 lakhs rupees for contingency amount, and every month for 2 years, 4 lakhs. It is made clear that net fee loan amounts, contingency amounts, and monthly deposits are hereinafter collectively referred to as interest-bearing refundable amount. Now coming to serial number 13, that the first party agrees that 1,75,345 square feet saleable area, which includes 25% super built-up area, falling onto first party share will also include the following: landowners allocation, etc., club of share, etc. So what he will get, it was quantified out of the FAR of 200 at that point of time. Now coming to serial number 15, that both the parties agrees that consideration, cash as well as area consideration by the second party to the first party is deduced on the basis of land area to be received by the second party on papers, that is government record and physically, is more or less measuring 13 bighas 4 letters, and same is subject to adjustment in the following manner: if the land area decreases on actual measurement or government record, and or if the second party is not successful in receiving desired FIR against the short area. These were also agreed to. Even if the FIR becomes lesser, then also he will get the same. His second meaning is that. And or if the second party is not successful in receiving the desired FIR against the short area, that if the land is less than 13 bighas 4 letters, then he will be entitled for less FIR. But both the parties have decided that the quantified consideration, which includes the monetary considerations as well as the share in the built-up areas, should be fixed. Now coming to serial number 19, clause number 19 at page 152. That the first party assures and covenants that it had assigned the rights, interest, and possession of the entire project to the second party by proper deeds, documents executed and registered in favor of the second party to assignment deed, etc., enabling the second party to either use the already sanctioned NOC obtained from the GMDA by the first party, and or this is actually not permissible. NOC permit, planning permit, these are not transferable, but however it is included. So there's an option, and or if required, to get the same modified, corrected, and or apply and fresh NOC permission in its own name from GMDA, GMC, RERA, Pollution Control, Fire Department, APDCL, etc. And for that purpose, also authorized to change, modify, rectify the drawings. This is again very important, Lord. So they themselves have given that authority to the other party. And for that purpose, also authorized to change, modify, rectify the drawings, layouts, plans, name of the projects, and can also change, appoint, remove any consultant wherever necessary. And the first party will not be entitled to raise any objections for that. Further, the first party had already facilitated and obtained that no objection of affidavits from the existing LOT for the said purpose as detailed in Annexure F, and handed over the same to the second party. Now keeping all this, coming to serial number 32 at page 155. May I read it? Serial number, clause number 32. That both the parties agree that the above 1,75,345 square feet saleable area is worked out, deduced based on the above referred existing NOC dated 3/11/2018, received by the first party from the competent authority prior to signing of this agreement, which only forms the area consideration to be given to the second party to the first party. And no further area share shall be given to the second party to the first party, even if the second party gets additional benefit to construct further area in any name or manner whatsoever under present provision of law of the competent authority. So the present position of law as on date, that means on 6th of June 2020, the law has changed in the meantime. So what, with his eyes wide open, Lordship, he has executed this agreement. Now, because of this problem he is facing, the hurdle he himself has created in his MOU as well as the deed of agreement, he is not being able to come out of that problem, and he is trying to involve this honorable court by filing this writ petition to settle his dispute with the other party on monetary consideration. This is the simplest case, the overall situation. Present provision of law is very clearly he has mentioned here. So whoever has drafted and whoever has signed, they were well aware that they have inserted this word present provision of law. In the earlier memorandum of understanding, Lordship, it was not there straightway, but here it is more specific. And finally, clause 49, there is the arbitration clause.
Page.
Lordship, it starts from page 57, clause number 49. That in the event of any dispute or controversy between the parties to this agreement should settle their dispute arising out of this agreement to the breach, etc., under Arbitration and Conciliation Act 1956.
Where is it? Clause?
Clause 49. It starts at page 157.
Okay. 157. 49.
So both this agreement very firmly binds both the parties about what they have to give, what they will receive. Givables and receivables are well defined. So there is no scope of getting any benefit by the writ petitioner, even if the other party is able to get more FAR under the new law. So to overcome that problem, this writ petition is filed by saying that
And you want to contend that it is not after even signing of the deed. It was before signing of the deed that there was an amendment.
There was an
and they were aware.
Exactly.
And that is for this purpose that certain
Exactly.
clauses have been inserted by which there can be changes in the constructions.
Exactly. And he has laid down his problem that NPA, then the whole project will go waste, all these things. And he has also said that 18.50 crores have to be paid to NETP, then 500 to the various flat owners and landowners, and also the monthly 4 lakhs rupees for a period of 2 years. All these things are mentioned. So I would not say that this is a distress sale, this is a distress agreement he entered into. Because of his precarious situation, he entered into. But why bringing GMD and GMC into this problem? That is my contention. So this MOU, this memorandum of agreement was not enacted initially. They did not want to disclose this before this honorable court. But at our instance, Lordship, they have filed it, and now they did not make a single submission. We are pointing out what is the salient features of this deed of agreement. Now, coming to, before taking your Lordship to my affidavit in opposition, I would like to take their reply also. In reply also, they have brought certain very interesting things, because ultimately it was the breach. So what is the history regarding the construction of bridge? That is also disclosed in this reply affidavit filed by the writ petitioner. And also, they were trying to mislead this honorable court by citing a honorable court's order of 2021. In 2021, all this planning permit, which was given on 10 September 2020. The GMC's NOC was given on 19th September 2020. They were now trying to bring an order of this honorable court, which Lordship will find at page 592.
Yes.
592, order dated 4/2/2021. These are all subsequent events. I am skipping the first paragraph, second paragraph. Aggrieved by the notification dated 19th October 2020. Lordship will kindly mark two dates that 10/9/2020, the planning permit was issued by GMDA.
This is by whom?
This is by the government in
No,
Guwahati
no.
Development Authority, and they are trying to say that
No, no,
there's a
who-
violation.
Who had instituted this writ petition?
This petition was in Assam Real Estate Infrastructure Development Association. I think the senior council was same. That is why he brought this to the notice of this honorable court. This is a part of their reply. That's why I'm bringing it. How they are trying to mislead this honorable court. I'll go to the paragraph also, the pleading, but this is the order.
Yes, what has happened here?
Aggrieved by the notification dated 19/10/2020. So 1 year prior to that, Lordship, 1 month prior to that, the planning permit and NOC was issued. Aggrieved by the notification dated 19/10/2020 issued under the secretary by the Government of Assam Guwahati Development Department, constituting a single window clearance committee with the departmental minister as its chairman. Writ petitioner, which is an association of real estate development, has approached this court by filing the present inter alia contending that the impugn notification is not only arbitrary and illegal, but also in conflict with the provisions of the state. We are not on this, Lordship. What this honorable court finally said at page 596, having regard to the facts and circumstances of the case in its entirety, it is hereby provided that until further orders, the single window clearance committee constituted by the impugned notification dated 19/10/2020 shall not in any manner interfere with the functioning of GMDA and GMC authorities in discharge of their statutory functions as per provisions of the Act of 2010 and the bylaws of 2014 with regards to sanction of planning permit and building permit. What they are trying to indicate here is that the report given by the 3 members committee, that has nothing to do with single windows clearance committee. They are saying that the committee's report is illegal. That for that I have to take a lordship to the paragraph which they have stated all these things. Paragraph 6, 580. With regard to the statements made in paragraph 10 of the counter, the petitioner company do not admit anything which are contrary. It is stated that on the onset, the impugned planning permit dated 10/9/2020. The committee, this single window committee was constituted on 20/10/2020. So these are all subsequent things. The impugned planning permit dated is illegal on 3 accounts. The permit was granted by a 3 members committee of the respondent authority in violation of constitutional mandate, the erroneous computation of average road width, and 3, non-consideration of the earlier reports given by the same authority while issuing the impugn. While with respect to the first contention of the petitioner's company, it is submitted that the impugned permit dated 10/9/2020 was issued based on the recommendation of the 3 members committee constituted for scrutiny and recommendation of planning permit proposal over 10 bighas of plot of land. It is submitted that the 3 members committee, which was constituted on 3/9/2020, is in violation of the constitutional mandate. It is pertinent to mention herein that a respondent number 1 by notification dated 19/10/2020 had constituted a single window clearance committee, and same is the subject matter of challenge in WPC so and so. And this honorable court by order dated 4/2/2021, I have just placed it, has directed the single window committee not to interfere in any manner with the functioning of the GMD and GMC authority in discharge of their statutory functions with regard to sanction of planning permit and building permit. Taking a cue from the aforesaid order dated 4/2/2021, it is discernible and that the constitution of any committees that is violative of statutory laws and as such 3 members committee constituted on 3/9/2020 is illegal in the eye of law. So this part.
But this was not argued by Mr.
It was
Kaur.
not argued, but these are in the reply they may argue. So I am pointing out because these are part of the pleadings. This was
No,
not
but-
argued this point, but for this I just want to clarify the
But it-
committee which was constituted for
No,
three
that is okay, but in the pleadings, is this point taken that as if the order of 4/2/2021 is also in violation?
Uh,
That is not the
that
pleaded
is not,
case.
that is not there. But what they are saying that the report, which I am going to place in my affidavit, they, according to them, that is illegal. Because it was done, it was submitted by a committee which is not constitutional. For that, my submission is very clear. Rule section 12 of the GMD Act.
GMD Act.
Section 12 of GMD Act very clearly says. Order.
Same book you are
Yes,
holding?
yes,
Which
Lord.
page?
Page 619. Section 12 says constitution of committees. The Guwahati Metropolitan Development Authority may from time to time with a view to give effect to the purpose of this act and other rules made under this act constitute as many committees consisting of such persons of following classes as it may think fit, namely members of the authority, persons associated with the authority, other persons whose assistance or advice the authority may desire as members of the committee, provided that no committee shall consist less than 3 or more than 7 persons. So it is authorized by the act. I'll produce those two notifications, the constitution of this committee, and in 2021, the committee was expanded up to 5 members. So trying to bring the High Court's order of 4/2/2021 in respect of single window clearance committee has nothing to do with the 3 members committee, which did the inspection to give the road width as well as the other specifications, particulars of the project. This is regarding the committee. I'll come to the committee's report little later. Now, regarding the bridge, they have stated, they have given a very long paragraph regarding what are the anomalies in the calculation. I do not like to read everything, but if Lordship permits, I can have it.
Indicate, just indicate, you can just indicate page.
Page 582, second paragraph. Another interesting fact emerges that the respondent authorities have neither brought on record the order dated 3/9/2020 nor any pleadings documents to the effect that under what circumstances the need of constituting the said 3 members committee arose. Further, the respondent number 5 applied for the permit on 1/9/2020 and within 2 days the 3 members committee had formed on 3/9/2020. The 3 members committee on 5/9/29 went to the site, visited just after 2 days of constitution for application which was submitted 2 days prior to the constitution. Pausing here for a moment, Lordship, my submission is that this committee was constituted. At no point of time they have challenged the constitution of the committee. So why we should justify why the committee was constituted in our affidavit? Because that was not their pleadings. In the writ petition, they have not said that the committee is in violation of any statutory law or any constitutional law. They have not challenged the committee. Neither they have challenged the committee, whether committee's report was challenged or not. Committee's report also was not challenged. Page 24 of the writ petition. They have challenged the planning permit dated 10/9/2020 and the GMC's NOC of 19/9/2020. And they have a further prayer that the affair should be 175 instead of 275. So these are the challenges. They have not challenged the committee, its constitution, or the report of the committee also. Page 24 and 25. So their reply that we have not justified the constitution of the committee will not hold the field. Lordship will kindly have a look of this. I'm just reading and I'll hand it over also. Order dated 3/9/2020. A committee has been constituted with following members for scrutiny and recommendation of planning permit proposals on plots area more than 10 bighas. Sri Ananta Kumar Gogoi, Secretary GMDA. Sri Deepak Pechborua, Associate Planner GMC and Town Planner GMDA. He was having dual role. And Debraj Kolita, Town Planner GMDA. This was issued on 3rd September 2019. Sorry, 2020. For all projects having land more than 10 bighas and above. This constitution or this order was not put to challenge at any point of time. Thereafter, on 2nd August 2021, 1 year later, when one of the member, Lordship, Deepak Bajbura, he was no more with GMDA, then a press committee was constituted. May I read it? Of 2nd August 2021 order. A committee is constituted of following members for examination and recommendation of the occupancy certificate proposals requiring regularization, etc., planning permit proposals in plot areas of more than 10 bighas, or any other issues relating to planning permit proposals as referred to the committee by Town Planner GMDA. Number 1, Ananta Gogoi, ACS Secretary GMDA Chairman. Dalim Gogoi, Urban Consultant GMDA. Debraj Kolita, Town Planner GMDA Member. Hitesh Sharma Medhi, Assistant Executive Engineer GMDA Convener, and Concerned Site Engineer GMDA. The committee shall meet as frequently as required to see that there is no unnecessary delay in processing the file. So this is a routine affair, nothing to do with the Magmolar project or the Protect project. And till now, in Guwahati, there are about 11 or 12 projects having more than 10 bighas. Others are less than 10 bighas. So this is a routine affair. Regularly, it has been done. So there cannot be any ulterior motive or no mala fide intention can be attributed to GMDA in constituting these committees. There should be fairness, because one person can go and give a report also. So when there is a committee, and Lordship knows so many High Court division bench judgments, at least from 2005 to 2015, when a lot of building deviations cases came before this honorable court, especially the division bench PL. So many directions were issued by the Honorable Guwahati High Court that if any officers of GMDA or GMDA is found to give false report or incorrect report, then they will be criminally prosecuted. I do not have to place those judgments. These are in the public domain, Lordship. So no officer, these are all qualified persons, number one, and they have a career. Nobody will play with their own career just to reduce the road width or increase the road width at any point of time. And these are all tangible things, concrete things. No subjective opinion is required. Only objective perception is required. Objective finding is required. When I say the road is more than 8 meters, it has to be more than 8 meters. I cannot go again and find that it is 7 meters. It cannot overnight, it can change. So their contention that this committee is illegal, it has nothing to be concrete enough to say that it is against the statute. Section 12 of the GMD Act 1985 clearly permits the authority for the purpose to go by the Act, Lordship. The committees can be constituted with minimum 3 members, maximum 7 members, and they should be connected with the activities of GMD. These are all ACS officers, well qualified engineers, Lordship. Nobody will have any interest of these buildings. But certain very demeaning things were also given. Page 583. Nonetheless, about 10 lines from bottom. Nonetheless, team members committee, after conducting a survey of such a big plot of land on 5/9/2020 itself, prepared its report and recommendation on Sunday, then TT, all this thing. And on 10/9/2020 issued the impugned planning permit. From the conjoined reading of the dates and facts, it is amply clear that the respondent worked at a lightning fast pace. This was possibly only because of all the aforementioned actions of the respondent authorities, like formation of 3 members committee, site visit, etc., are only an eye wash, and the veil has been to be lifted to understand that all these actions were done just to give some kind of legitimacy to bestow undue favor of Honorable Minister, wherein by virtue of increasing the road width to 8.35, the respondent number 5 sought to gain more than 150 crores. So this gentleman was not a minister at that point of time.
Okay, we take a break.
The respondent number 8 sought to gain more than 150 crores. Moreover, another fact needs to be considered. In the month of September 2020, the state of Assam was under the grip of COVID pandemic, and most of the offices were not fully functional, save and except emergency services. But the planning permit of the respondent had got approved within 5 days, whereas planning permits of under normal circumstances for common public takes 2 to 3 months. From the attending fact, it can be safely inferred that DMD officials are hand in glove with respondent number 5, and most probably have received a substantial portion of pie of 150 crores. These are straight to defamatory statements. I do not want to make any comment, but the statute itself allows or binds the authority to give the permit within 10 days. The other day I had placed that particular rule.
Yes.
So I placed the rules the other day, Lord, that within 10 days it has to be given, and if it is not given within 45 days, it is considered to be deemed permission. Then next page, 585B, assuming without admitting that the 3 members committee is validly constituted, perusal of the minutes of 5/9/2020 clearly reveals the erroneous computation of average road width for the purpose of determining the permissible affair of the said committee. The 3 members committee took recourse to paragraph so and so to calculate the average road width. So these are, I'm going to place the report. According to him, these are erroneous. That entry point 8.05 in front of plot 12.50 meters and minimum width is 4.5. As per the report of 28/12/2013, the average road width of Tarunnagar byline was 7.5, and the report indicates the methodology as to how the average road width was arrived at. At that relevant point of time, the building bylaws 2006 was prevalent, and section 20, which is parameter to section 23 of 2014 regulations, which dealt with the calculation of average road width for the purpose of calculating FAR. Further, as per aforementioned report dated 28/12/2013, the average road width of Anil Nagar byline was 4.6. Now the 3 members committee, while calculating the average road width, ought to have calculated the in the following manner. So entry point Namghor 8.5 in front of plot 7.15. So when it is 12.5, how can his committee can state that it is 7.15? Because their reference is of 2013 report. In 2013 report, that 4 meters was never given up by the authorities, by the petitioner. And as on date, report has to be calculated, considered. So in front plot 7.15, I do not know. Suppose when the road width is 12.50 or 12.5 meters, and the committee gives a report that it is 7.15. When it will be challenged before the court of law, how the committee will justify or how the GMDA will justify that? The prevailing situation has to be assessed. That is why the committee went and measured. If today I go there and I have to do the measuring, what will be the thing? In 2013, it was 7.15 and today it is 12.5. What figure I will give before this honorable court? As it is existing as on date, the present situation, I have to disclose that only. And on the basis of that only, the affair has to be assessed. Not the historical facts. And he himself, little later I'll place, he himself have given up that 4 meters of land. So when in 2019, when the project was handed over to the respondent number 5, it was 12.5 meters road. It was not 7.15. Had it been 7.15, Lordship, he would not have got 2 FAR in 2018 or 200 FAR in 2018. So now, according to him, as such, the average road width of Turunnagar Byline 2 comes to 6.57. This is the fourth figure he is saying. His original 2 permit says proposed road 8.5. Then 18 report says 8. 17 report says 8. In another statement, he has said it is below 8. Now here it is below 7 also, 6.57. So 4 figures he has disclosed in the same writ petition. In the same writ proceedings, Lordship, he has given 4 figures. First, he have to ascertain himself what exactly is the figure. Because every day the road width don't change. It takes years. So in this paragraph, he said that the road width should have been 6.57. So at one paragraph, he said it is 7.5. At one, it is 8.0. At one, it is 8.5. And now he is saying 6.57. So according to his own convenience, just to do proper bargaining, he is changing his position. However, the 3 members committee, instead of considering the actual road width in front of the plot, considered 12.50 meters as because respondent number 5 is moved the boundary wall backwards. Here he has made a huge mistake. I would not say it is a mistake. It is a deliberate incorrect statement. Respondent number himself moved the boundary wall. Little bit later, Lordship, that will be very much apparent. This action of respondent number 5.
Respondent or the petitioner himself?
Sorry, it was done by him, petitioner, at the time of construction of the bridge. This action of the respondent number 5, as well as the action of respondent authorities, is wholly illegal and against the spirit and mandate of bylaws. See, again assuming without admitting that the 3 members committee has the statutory competence, now he has indicated that there is section 12 of GMDA. It is submitted that the recommendation dated 5/9/2020 is untenable on the ground that the three members committee nowhere mentions about the long history associated with the plot. When they are going to find out the current position, the current affair is required, not the history. What was there at 3 meters or 5 meters or 7 meters, 8 meters does not have any relevance. The affair has to be assessed as on the present condition, the road width as it stands today under the new law of 2020. So nowhere mentions about the long history associated with the plot. The said plot of land was in the midst of litigation since long. Further, the project was envisaged in the year 2009, and thereafter a number of reports, orders were in existence with respect of the project. The three members committee did not even make a whisper of order dated so and so, so and so, so and so, and the order dated 2016 WPC. The letter dated 9/1/2021 paragraph 6 mentioned that the petitioner company was supposed to spare a private thoroughfare of 20 feet width across the project site from the south to north, directly linking the Torunnagar byland in disaster situations for use by general public and disaster management teams. The three members committee nowhere talks about why the recommendation letter dated 9/1/2015 and other subsequent letters were given a go by. To the best of the knowledge, the petitioner's company no such road exists in the present project. That they will definitely reply. But this road
Thoroughfare.
This thoroughfare was proposed by these disaster management authorities that in case of any disaster, that road can be used by the other people. So for that, a separate public interest litigation can be instituted. But we have verified, Lordship. The road they want is 24. Now, as on date, there is a thoroughfare of 26 meters, 2 meters more.
26 feet.
Sorry, 26 feet. I'm sorry. With the setbacks and all. Much more than what was required.
There is.
Yes, there is, Lordship. But that was not challenged. These are just pleadings they are making. Thus, it is seen that the above three members committee is illegal and its report dated 5/9/2020 smacks foul play to favor the respondent number 5 and in turn the honorable minister to get a windfall profit of 150 crores. So this is their contention. How vague it is. So they have neither challenged the report nor they have filed a PIL that the road is not there as proposed. In one of the letter, that was a communication from one authority to another authority. It has never fructified to an order. It was an internal communication. I'll place that I have gone through it. It was an internal communication. If that condition is to be inserted, Lordship, then it should be in the planning permit or in the NOC. That if that road is actually required.
Are you continuing to say that in the original planning there was no provision of such road?
No.
It came into. It was a later
it was the internal communication when those proceedings were going on regarding the construction of the bridge.
Okay.
So in none of the NOC or planning permit, Lordship, there is this particular stipulation. This stipulation was never there in the 2009-2010 road NOC or planning permit, neither in 2017 or 2018 planning permits or NOCs, and nor in 2020's planning permit as well as the NOC issued by GMC. So this clause was never there. So these are the facts from their side, whatever I have placed. Now let me place my case. Lordship will kindly take our affidavit in opposition.
Page.
It is page 160, 160. Filed by Sri Debras Kolita, the town planner of GMD. Page 163. My first ground is, Lordship,
16.
Yes. Have Lordship got it? My first submission is, Lordship, that the writ petitioner have not approached this Honorable Court of Equity with clean hands. Why I am saying it, Lordship? If Lordship comes to prayer number Roman 2 at page 25 of the writ petition.
Yes.
Why a certiorari should not be issued for setting aside and quashing the decision of the respondent authorities to grant FIR 275 to respondent number 5 instead of FIR 175. What is his position when he entered the MOU and the deed of agreement? He took 200 FIR. He himself got the benefit of the road width of 8. At that point of time, beyond 8, there was no increase in the FIR. So he himself enjoyed 200 FIR and did the this agreement with the private respondent number 5. He was happy. At that time, there is no illegality, nothing. Now, when the project has gone out of his hand, he wants that the FIR should be reduced to 175. Is he not playing with this Honorable Court by this prayer? The intention of the writ petitioner is not it's not bona fide. The conduct in 4 different places, he have quoted 4 different road widths. When he took the first NOC in 2009 and 2010, the road width, according to him, was proposed to be 8.5. During the proceedings before the Deputy Commissioner, he wrote a letter that the road width is 8.5, 14/1/2000. I have placed it in the report at page 182 for a moment. Lordship will kindly see. These are repetitions basically.
— 182.
Page 182, last one, XX Civil Roman 24. A letter addressed to ADC on 7/1/2014 by MS Magmolar Estate and Private Services Limited, elaborating that the proposed project is having tri-connectivity to the main arterial road, namely from GS Road, although Torunnagar by lane number Roman 2, average road width 8.5 meters. So he himself says. Then Lordship will kindly come to page 580. When we pointed out this is his admission. He has accepted this.
580.
580. Regarding this letter. They have not submitted, but these are part of the record. If the matter goes to the appeal, all this they will be highlighting. That's why I am trying to touch every point which they have raised in this proceeding. Paragraph 5. 580, Lordship.
Yes.
The petitioner company do not admit anything which has been stated in paragraph 7, which are contrary to record. The petitioner company submits that it admitted that it had stated in its letter dated 7/1/2014 that the average road as being 8.5 meters. He has admitted it. Now later on he said that it should be proposed. I do not know, Lordship. When we pointed out, he will always come with an excuse. However, the statement made therein based on NOC dated so and so, wherein it was mentioned 8.5 and the word proposed was inadvertently missed out in the letter dated 7/1/2014. Nonetheless, it is submitted that the writ petition company is unable to fathom as to how this factum lead to the conclusion that the writ petition has no legs to stand or approaching the Honorable Court with clean hands. So here, according to him, before the Deputy Commissioner, it is 8.5. Just now, little while ago, in another paragraph, he said it is 6.57 should be the correct road width. While he has submitted the proposal for enhancing his FIR from 175 to 200 5 days later dated, that Lordship will kindly find that later. at page 186 now in my reply affidavit. Which is later is of, I think it is 25/9/2018. Although the date is not very clearly legible. May I read this later?
Yes.
In reference to above, we would like to bring to your kind notice that all the pending cases so and so has been dismissed by the Honorable Guwahati High Court by order dated 27/8/2018. The copy of which is annexed herewith as Annexure A. That due to the pendency of the above cases, NOC of building construction against our file number so and so was granted on us 17/5/2015 with restricted FIR of 175 against permissible FIR of 200 as per the technical committee meeting held on 13/5/2016. Now, as all the pending cases has been dismissed by the Honorable High Court on 27/8/2018, we request you to grant the permission FIR of 200 as substantial investment has already been made in the project and the various past delays and restricted FIR of 175 has drastically affected the financial viability of the project. Please note that the project is having high connectivity and the company has fulfilled all the stringent preconditions which were levied on various occasions by the various competent authorities. Hence, pertaining to above, we are submitting herewith the undermentioned documents for granting us the permissible FIR of 200 against our file number so and so in the context of technical committee meeting held on 13/5/2006. He himself applied for 200 and he obtained it also in 2018 in terms of this letter and the proposal submitted.
Where is that?
That lordship, it is 2018 of permission. 2018 is there in page 117. Where figure will be very difficult to find it out. In the this is page 117. Page 116 and 17.
Yes.
The FIR figure immediately I cannot. From the measurement lordship, we will have to find out. It is 8. It is 200. Straightway it is not indicated, but from the measurements and in our file we have it is 200. So I'll place that record lordship, and there is no dispute on that otherwise. I'll place that paragraph. In paragraph 13, they have admitted it, lordship.
Of the writ petition?
Yes. Yes, paragraph 13. The above continued when the permission under the NOC was granted based on actual road width and not proposed road width, as no objection certificate granted in the year 2017 and 18 indicate that the actual road width was determined to be 8 meters and FIR allowed was 200. It is pertinent to mention that the FIR 200 was granted because yes, granted. It was granted because the approval of that was given on the basis of 2006 bylaws, where the FIR allowed by road width of 8 meters and above was 200. The 2014 bylaws also reflected the same computation as 2006 bylaws. So he got it on the basis that the road width is 8 meters or above. He himself has written this. 8 meters and above. Now, this committee found that what is the measurement beyond 8 meters, and it was found that 0.35 is the measurement. So the road width was finally found that it is 8.35 or 34. So that is why, due to the amendment in the laws of 2014, where beyond 8 meters road width, the entitlement is increased from 200 to 275.
But why in the 116 and 117, the width of the road is written up to 8.0 m?
8.0 m.
Yes.
At that point of time, it was not required because he said 8. He
No,
said
this is by you.
it is by you, us lordship.
Yes,
Because
DMTA.
prior to that, it was 8.5. His earlier road width, if lordship is pleased to look at the earlier ones for a moment, the proposed ones with the without the bridge, that lordship will find that page 114. Says,
Yes.
proposed 8.5 meters wide. Here with condition number 3 says construction of the bridge is to be started as per the NOC dated so and so. So after 2016, when the bridge was completed, both the NOCs given in 2017 and 18, this condition of construction of bridge is no more there. They have come to a concrete conclusion that what is the existing road width. So at that point of time, anything beyond 8 has no relevancy. The relevancy evolved with the passing of the amendment on notification of 5/5/2020. There, another criteria has been inserted that between 8 to 15, beyond 8 and below 15, it is 275, and beyond 15 is 300 FAR. Provided they have a land area of minimum 10 acres. So my submission is that they have not come with clean hands. And before going to the next ground lordship, his reply also mentioned about the story about the construction of the bridge. Those lordship will find 2-3 orders. This is the letter which I was mentioning, lordship, page 602. Letter dated 9/1/2015, wrote by the CEO GMDA to the Deputy Commissioner, Kamrup Metro. In inviting reference to the above, I would like to state the following in connection with the construction of the bridge by Magmolar for your kind consideration. Paragraph 1, NOC for construction of bridge was issued by letter dated 22/10/2009 and water resources notice dated 15/7/2009. Subsequently, on the basis of the bridge and Torunnagar Island 2 as the main access road to the project's NOC was in favor of Magmolar was issued on dated 10/11/2009 and so and so. However, the NOC could not be renewed or extended as the said bridge could not be constructed by the party concerned. Lordship, this is a letter of 2015, 8/15, 9/1/2015.
Yes.
and stop construction notice had to be issued for not having a valid NOC as on date, that is 7/11/2014. This authority is also not in a position to issue NOC for the remaining 3 blocks in absence of the following aforesaid bridge. The construction of the bridge across Bhorulu River at Chenes so and so, linking to Torunnagar Byline 2 and Anilnagar Byline 1, will certainly enhance the connectivity between the two sites. And in disaster-like situations, disaster management teams may operate to the road bridge link to serve the inside localities of Nobin Nagar and Anil Nagar directly to the project site as proposed by the petitioner. So this road he has proposed. The developer Meghmolar Estate is to abide by all the terms and conditions put in the NOC of Water Resource Department and GMDA for construction of the bridge. The bridge should be treated as a public bridge once completed and accessible to general public on all occasions. The developer Meghmolar shall have to agree to spare a private through fare of 24 feet width across the project from south to north, directly linking the Torunnagar Byline 2 in disaster situations for use by general public and disaster management team. Special care is to be taken so that the movement of machineries for cleaning and desilting the river canals is not disturbed due to construction of the bridge. So this is a communication from GMDA to the Deputy Commissioner. It has not culminated into a condition in any of the NOCs or building permit. But in spite of that, if Lordship insists, will continue and ensure that this thing is in place. But my instructions from the committee members is that Lordship, there exists a 26 feet passage now. The project is still going on. Instead of 24, it can be expanded to 26 feet now. Although this is not a condition precedent for construction of the project. And also thereafter, Lordship will kindly see the order, page 604, the story of the bridge, little bit, Lordship. May I read the first line? As per the order passed by the Honorable Guwahati High Court in WPC so-and-so dated so-and-so, the Deputy Commissioner cum Chairman District Disaster Management Authority shall take up the above representations submitted by the petitioner on board and consider the same on merit. Having regard to the nature of the grievance expressed by the petitioner, the Deputy Commissioner shall give a personal hearing to the petitioner and also may obtain relevant report from the stakeholders. Peruse the order from the Honorable Guwahati High Court dated 4/12/2013. Accordingly, all the stakeholders, namely the petitioner, the complainants of Torunnagar committee, all the concerned department were asked to appear with all the relevant records of the hearing. Here, this was in terms of the Honorable Court's order, which Lordship will find. I have gone to that order.
7057, 20.
Yes, there's a direction. There's a complaint from the local Samiti Lordship that the bridge should not be constructed. And the Honorable Court directed that there should be a proper hearing. So various reports were taken into consideration, and during that hearing, the Meghmolar submitted that letter that the road is with his 8.5 meters at page 609. And finally, at page 611, I would like to read one paragraph from the top. H. NOC given to Meghmolar Estate, I dated 10th November 2009 and 29th July 2010 for consideration for construction of G+8 and G+6 flats residential apartments at village Japurigog of Beltola, number so and so, on proposed 8.5 meters road without considering other points. In the said NOC, it was stated that the construction of bridge is required to be started as per condition of the NOC of GMDA dated 22/10/2009 after obtaining due approval from the Water Resource Department, is received for dismantling the existing wall. The construction of the proposed bridge over the Bhodolu River would act as a hindrance to ingress and egress of the people in general, and particularly to those residing in bylaw number 9, as well as extended portion of bylaw number 2 up to Hindustan Kendriya Vidyalaya, only secondary school in the locality. There are 2 public drains, etc. To overcome all these issues, that 4 meters land was given up by. Coming to the findings. Next paragraph, the permission by GMDA should not have been given in the first place because of the following reasons. This is the opinion of the Deputy Commissioner. The plot of proposed apartment exists in the northern side of Bhodolu River in Anil Nagar area. Though there are 2 lanes in Anil Nagar area connecting to the plot, but the width of the lanes are not in proportion to the number of units planned in the plot. The building permission given to Meghmalar is based on a proposed road across Bhodolu River in Tarun Nagar side to be connected by proposed bridge over the river, where the permission so granted should have been on existing road in Anil Nagar side. A proposed road cannot be the criteria of giving permission, especially of a massive residential project. The bridge was proposed only to facilitate.
This opinion was later on changed.
Yes, Lord, that is what.
After the bridge.
After the bridge. Then again, the Tarun Nagar committee's order, that is also important, but in the meantime, another report at page 623, 25/1/2016.
Yes.
So in 2014, the final opinion was given by the Deputy Commissioner at that point of time, was that it can be concluded that the necessity of the bridge is rejected outright at page 611, last line. Issues raised to the public complaint are observed to be genuine in nature. Last line of 611. So the construction of bridge was rejected. And next page also, as such, considering all aspects, aforesaid, it is directed that CEO GMDS shall review the NOC and fix responsibility on those who made an attempt to maneuver facts to facilitate the permission despite non-existence of the road of stipulated width as required by law. He shall also explore all other options of connectivity and review the NOCs given. So this was the situation, Lord, that manipulation of road width, etc. were the subject matter of the earlier proceedings. So in this kind of situation, nobody will take the risk or invite danger to their career or to their profession by giving false measurement. Road means, Lord, the definition of road is by law of 2006 also I'd like to place, or same definition still is continuing. 2.52, road means and include any highway, street, lane, pathway, alley, passageway, carriage.
You are reading what? 2.5 of?
2.52 of the building bylaws of 2006.
Building bylaws.
Page 272.
Building bylaws.
Same book, Lord. Little while ago, Lord was taking this book. The same book.
Oh, this has got the building bylaws. Which page?
Page 272. I am placing the 2006 bylaws because the deputy commissioner in 2014 held that the permission given in 2009 and 10 were erroneous.
272.
272, clause number 2.52.
Two point five two.
Yes.
Road.
Definition of road. Road means and includes any highway, street, lane, pathway, alley, passageway, carriageway, footway, square bridge, whether private or public, whether thoroughfare or not, whether existing or proposed in any scheme, culverts, sidewalks, and traffic islands. So, when a building permission or NOC or planning permit is granted lordship under the law, a proposed road or proposed width can also be considered. That condition is given. And at that point of time, only 2 blocks were permitted, not 5 as on date. So when 175 FIR was given in 2009 and 2010, on the basis of proposed road width of 8.5, 2 blocks were allowed with a condition that there should be a bridge. The bridge ultimately did not happen till 2014 because of public complaint. He came before the Honorable Court. The Torun Nagar Committee came before the then court said that go for a hearing before the Deputy Commissioner, and Deputy Commissioner upheld their complaint and finally concluded that the necessity of the bridge is outrightly rejected. Thereafter, the Machbalar and others came before this Honorable Court. And there is a judgment at page 617, is a common judgment. It starts from 613. So Torun Nagar Unnayan Committee 1 party. Page 616, Machbalar Estate, WPC 1783 2017. So a common judgment was delivered. Page 617, four writ petitions were taken together, and 1783 belongs to the present writ petitioner. All the 4 writ petitions were heard together, and today is fixed for delivery of order. So various issues were considered, and finally, at the Honorable Court, at page 619, Lordship.
Yes, the order is dated 27/8.
27/8. Second paragraph, 619.
619.
619. This led the builders to approach the court by filing 7057/2013, which was disposed of by order dated 4/12/2013. That was the hearing, by directing the Deputy Commissioner Kamrup Metro, Chairman of the District Disaster Management Authority, to consider representation filed by the builders by giving personal hearing and after obtaining relevant reports from the stakeholders. It was directed that the necessary decision shall be taken by the Deputy Commissioner within a period of year. He came before the Honorable Court because the NOC for the bridge expired and it was not extended. The Deputy Commissioner Kamrup passed an order on 24/2/2014, taking the view that the GMDS should not have granted permission for construction of bridge over the river Bhorolu, as well as the building permission for residential apartment. However, the builders submitted representation before the Deputy Commissioner Kamrup to review the aforesaid order. The Deputy Commissioner had called report from various authorities such as GMDS, City Police, GMC, PWD, and Water Resource Department, whereafter the Deputy Commissioner passed order on 25/1/2016. It was stated that from the various reports of different agencies, it was quite apparent that the necessity of the bridge was established and it will enhance the connectivity between Anil Nagar and Nobin Nagar on one hand, with Tarun Nagar Pylon 2 on the other. Therefore, the Deputy Commissioner declared that he would have no objection if permission was granted by GMDA or by any other authorized authority for construction of the bridge over Horulu River under strict supervision of Water Resource Department. Therefore, GMDA was requested to review the earlier NOC and to issue a fresh NOC keeping in mind the suggestions made by various agencies. Thereafter, GMDA issued fresh NOC to the builder for construction of the bridge. For pausing here for a moment, Lordship. In one of the communications during this proceeding, that private land has to be given. A part of the writ petition, page 128.
One to eight.
1 to 8.
Yes.
Here, serial number
3.
3, as regard to mentioning of proposed road width of 8.5, mentioned in the NOC, it is stated that FIR is allowed based on existing road width and proposed road is considered for determining the front setback so that provision of road widening in future may be facilitated. So these are all in the loop that somebody will have to give land so that the road can be widened. If I may continue at 2.
Yes. There is a meeting now. It may be 10 minutes here and there, but we'll try to come at 2 o'clock.
No difficulty, Lord. I want to complete today because from next week I am not available for a matter in day to day.
Mr. Das is eagerly waiting.
He will earn the jackpot. Lord. That 150 crores will go to him.
He said first down, second down.
All along the minister will get 150 crores. So he is the person representing them.
Okay.
Deeply applied.
So item number 68. If time permits, whether after this item your lordship will take up my matter. It will not take much time, 10 minutes on maximum. All right.
Motion going to us.
I've collected documents.
That Reliance matter.
Yes, sir. I've
What-
collected. It's got that.
Who is on the other side?
Petitioner has.
Mr. Saikya, just a minute. Some motion. 6-2 ki motion to you. There's one motion, I think. Yours is a motion matter.
No, it's the vacating.
No, there's a motion matter. Kuntu? Yes, Mr. Chaudhary. Where is he? Madam Bora? At 2 o'clock it was fixed.
My lord, I have a prayer for interim order also. Therefore, in their absence, my lord, if difficult, my lord may fix it on Monday.
If you can wait till Monday, very good. Monday we'll have then.
Monday. My lord may indicate that matter will be taken up in the absence of that standing council also.
No,
Then-
Standing Council will be here, don't worry. Those three, as Goswami, SS Goswami learned counsel for the petitioner is present. Comma. No, when, comma, the learned standing counsel for the department. Huh? Mr. Goswami says that he can wait till Monday. But Monday, ask him to come. He's got an interim prayer also. Let us consider whether we grant or not. That's a different matter. Is present, short accommodation has been sought for on behalf of the Learned Standing Council, Agriculture Department, Para. In view of the above, list this case for motion on Monday. Right. Mr. Chaudhary. Now, if you are here, we can have the matter. What is it? Or he says that Monday also we can have.
Oh, that's it. I took the instruction. As per the instruction, after the submission of the case, it can every details bit debate and then they were given the reason for either detection.
Sit for a while. You are running short of breath. 1 minute. We are giving 1 minute time. Even in T20, there is a break. Drinks break. Take your breath. No, really, we are. Wait for 10-20 seconds.
No, it's okay.
It's not okay. We know the problem. We have faced a number of times.
They have been informed and we can got any grant. I doubt in the Korean whereby the experience was modified. They also have approached our that was opportunity is still there. But the technical evaluation.
What is the status now?
Technical evaluation has been done. Now the redundancy minimum has got it has been submitted. Many of them has submitted. That would be again care of the.
Why didn't you approach the authorities? We can record his statement. You approach the authorities.
Kindly say NIT condition. We have objected on the pre-bid meeting and they have assured us that we will upload a corrigendum. We will accept your suggestion. And corrigendum issued is completely a different corrigendum against the law, my lord.
Okay, Monday we'll have.
My lord.
Heard Sri S.S. Goswami Learned Council for the petitioner. Full stop. Also heard Sri B. Chaudhary Learned Standing Council, Agriculture Department. The matter pertains to a notice inviting tender. Full stop. Para, as agreed to by the Learned Council for both the parties. List for motion on Monday.
Okay.
I've given the top.
Who's for the other side?
They are not in the morning also. Today is now they are not there. But the day. No, 60. 60. My lord, government, my lord. First, I've given the guidelines. Department of Telecommunication has a portal, my lord. Tarang Sanchar portal. Page 73, I have shown, my lord. ID is generated by DOT, my lord.
Yeah, that is okay. Where is your?
Yes, lordship may see number 2 page that this is issued by Department of Telecommunication. This EMF simplify. EMF means, my lord, electronic magnetic field, my lord. Then 3rd page is important, my lord. Lordship may see the first line, my lord. This is EMF portal as per Government of Telecommunication, my lord. Proposed test emission start date 10 June, lord. Lordship see that written there.
Where is it?
Proposed test emission start. That is in the middle, down below. Then actual test emission.
I hear us.
But he's there, my lord. Then lordship may see actual test emission start 9 June. That I've shown page 73. Then OSS snapshot. Then down below, self certificate prepared and sent to nodal officer 10 June. Submitted by nodal officer 10 June. So this is the thing. Then on the right hand side, the site, tower site is there, my lord.
Yes, what do you say? How does it matter? There is a stay order in your favor based on a on a submission made by you that the towers have not started commissioning. He's showing the paper the towers have started commissioning. Where is the basis of passing the stay order?
At the time of filing, the tower was not.
No, what is the date of the order? 1610.
1610.
Tower started on the 10/6.
And
Much prior to even filing of the writ petition.
But the operation was.
It was operative, it was starting
Kindly page number 103.
of the,
Next certain photograph. To operate the tower, the electricity connection is necessary, and I have submitted some PS.
no, there is an official document. The tower is in operation since June, not only marginal time. This order is of October.
And I've presented the electricity bill also, my lord. The serial number 5, lordship, Mr. Electricity bill. I have other bills, but
Had it been on a different consideration, the order of stay, matter would have been different. Order of stay is only on your submission. That the petitioners in paragraph 25 has averred that installation work is complete, it has not yet started functioning. Only on that ground. We will not stop the functioning. Otherwise your challenge will still be alive.
To work on the installation of underground electricity wire was going on. It was on 10/09/20. 10/09/20. I have next to that ticket photograph.
There are documents from the authorities giving the dates. We did not take into consideration his document. We said that your application is not enough. We need an acknowledgement from the in spite of your absence. It's not that he produced the document on the basis of that we vacate this stay. We said this is not going to be done. Your statement versus your statement made by the respondents, those part we cannot adjudicate. But he has produced the document by the authorities. You have a look on this. Give him a copy. Heard. I took one. Yeah, Mr. Where is the I?
Thank you.
itu नहीं itu नहीं itu हाँ okay, we'll have this on Wednesday. You take some instructions. Today is the first day, okay? But give a copy of the Third Sri J. Roy, learned senior counsel for the petitioner, who by means of this application has prayed for vacation, cancellation, alteration of the interim order dated 16/10/2023, passed in the connected WPC 5853/2023. Full stop. It is submitted on behalf of the applicant that the aforesaid interim order, which was passed ex parte, who are the applicant was taken into consideration an averment made in paragraph 25 of the writ petition that the tower in question was yet to start functioning. Full stop. Para. It is the contention of the learned Senate Council for the applicant that the statement was erroneous and the tower has started functioning on
Comment.
10th of June 2023. Which is much even prior to filing of the writ petition. Full stop. Para. Be that as it may. What is your name? Sri J. Deka, Learned Counsel, appearing for the opposite party writ petitioner, prays for some time to obtain instructions. Full stop. Para. In the interest of justice, short time is granted, directing listing of this matter for consideration on Wednesday next.
On 6th, my lord.
Wednesday. Interim order passed earlier to continue till the next date of listing. Hey. Yes.
So regarding relinquishment of land, there is another document they have annexed.
We were in 617, the judgment in the earlier case.
Yes. But just, I want to point out that. Regarding relinquishment of land, who actually gave up the land?
Frontage.
618.
118.
118 of the.
Yes, please.
It's a letter written by Punup Pagya, the managing director of the Commissioner's Company, Manpower, Manutala Protect Office. On 19/2021, first page they have about this spirit of the law and all. Serial number 2. The applicable FIR for the Nagar project as per bylaw 177 on 275. Next page. Your attempt to claim benefit by seeing the non-legal the adjacent road do not form a part of the resident. So, as per the calculated code at excerpt is number highlighted we can put it for convenience of reading. Missing link between the road developed by PWC up to the base point a minimum of 4.5 meters, which should be constructed by the developer at their cost, if required by relinquishing land from their own for making the bill accessible to the public. So this report they are hiding from this honorable. They have just quoted a part. If they are so fair, they should have given this document. And this report, I am sure it was about 2014 scaling. So here report itself says the report must be some government of. They indicated that it required that the access to the bridge, the road is not wide enough. And for that purpose, the road has to be constructed. This report dates back prior to construction of the bridge. So if Lordship directly have to place the complete report, the whole thing will be the light. But it is very clearly prepared by relinquishing land from their own cost for making the bridge accessible to the public. Only the bridge over the road will not be sufficient, along with the access road, approach road. So this is one part, and also I'll come to that page a bit later, but let me continue with the.
Okay.
So that is 690.
Okay.
However, the builder submitted representations before the Deputy Commissioner Kamrup Metropolitan to the appointed order. He had
Yeah, no. Yeah, like you. Page 617.
619.
619. Yes.
These are the developments regarding the construction of the bridge. However, the builder submitted representation for the Kamru to review the aforesaid order by physical suggestion. The Deputy Commissioner has called for report from various authorities such as KMDL, WP Water and School. Whereafter the Deputy Commissioner passed the order dated 25/1/2016. It was taken from the various reports of different agencies. It was quite apparent that the necessity of the bridge was established and it will enhance the connectivity between Anil Nagar and Nambit Nagar on one hand, the Nagar byline on the other. Therefore, the Deputy Commissioner declared that he have no objection to permission was granted by KMK or by any other authority for construction of the bridge over Borodo River under the strict supervision of Water Resources Department. Therefore, KMK was requested to review the earlier NOC and in mind the suggestions made by various agencies. Thereafter, KMK is to the builder for construction of the bridge. Second paragraph next page. In the meantime, the builder has constructed a steel bridge over River Borodo as per condition laid down by the Water Resources Department Government of Assam and as per bridge NOC issued by the KMK. It was informed to the KMK by the Water Resources Department that on 2016, in the meantime, the NOC issued by KMK to the builder for construction of residential apartment of Borodo Nagar had expected the builder had submitted applications and reminders for renewal of NOC. The CO came here on 9/12/2016 about pendency of their submission. It was stated that since the matter was submitted, KMK was not in a position to take the decision for on renewal of the NOC. In last paragraph, on the backdrop of the aforesaid factual metrics, the following issues right for the consideration construction of RCC over River Borodo, connecting the plot of construction to the byline. Number 2, construction of residential apartments by the builder. So far as the first issue is concerned, from the subsequent order dated 25/1/2016 of the DC, it is seen that the report from all the related agencies indicated that there was necessity of the bridge over the River Borodo and that could enhance connectivity between Borodo Nagar byline on one hand and Anil Nagar and Srinagar on the other. After considering all the reports, the Deputy Commissioner declared that he had no objection to permission was granted by the construction of the bridge, which should be carried out under the supervision of Water Resources Department by maintaining proper gradient. Thereafter, builder obtained permission from the Water Resources Department for construction of the bridge. The design of bridge was approved by the BWD. Following the same, KMK granted permission to the builder for construction of the bridge over the river. As per report dated 19/11/2016, the bridge was completed as per conditions laid down by the Water Resources Department. What I am trying to emphasize from here that on this date, 19/11/2016, the bridge was completed. By that time, the road was wide, also widened. The whole scenario had changed. The whole topography and the location has been changed. So there is no scope of the present builder to give away land to increase the affair or to widen the road. These things happened in 2016 itself. In such circumstances, there is hardly any scope for the report to interfere with the matter regarding expense of NOC for construction of bridge, which in the meantime has been fully executed. This is a matter of administration on the basis of technical expertise. In such matters, court should show due deference to the views of the experts and administrators accordingly not regarding the second issue, the regulatory bodies entrusted with the task of regulatory construction of buildings in Guwahati Metropolitan Region and thoroughly examined the pair of the building and had thereafter issued NOC. Following the intervening development as discussed above, the need for place NOC erosion, which has now been by the builder. Construction of the bridge was one of the preconditions for allowing permission to the builder to construct residential apartments. The original lordship has no clause number 3, precondition number 3.
The precondition having been fulfilled by the builders by following the stringent conditions stipulated in the NOC, it would be wholly unfair and unjust to withhold place NOC to the builder for construction of the residential property. As a matter of fact, KMK has placed NOC to the builder, placed NOC to the builder on 17/5/2017. It is not under challenge in any process. That being the position and taking overall view of the matter, the court is not inclined to entertain the instance of the objection. That's the Torun Nagar. So in that view of the matter, Lordship, case NOC was given in 2017, 175 FIR. Next year, he applied for enhancement up to 200. That he obtained. Original condition that bridge has to be constructed because at that point of time in 2009 and 10, the permission was given to be with the condition that the bridge will be there, and in the meantime, they have taken into account consideration that the road width of the proposed road will be 8.5. So all these has come into a particular situation. Once that bridge was constructed. So in that view of the matter, there is no question of that the road which was proposed in 2009 and 10, and there is additional 4 meters of land which was done during this tenure, during this term, when it was at the helm of it. On the basis of he has taken FAR also. So all of a sudden, the road we cannot keep decreased. It cannot come down. So this order of the Deputy Commissioner Lordship will find that because they have faced. And yes, the report of the Deputy Commissioner 25/2016 case. We had a second round of hearing. May I read it, Lordship?
Yes.
Second paragraph, where the construction of the bridge which was rejected by our earlier order dated 2/4/2014 was reviewed as from perusal of various documents on record, particularly it could be seen that the construction of Mandinagar Byland was conditioned for construction of the bridge and the other road. Fire Kendurali was approved by PMA as per extended building permission granted thereon. Therefore, the observation that the road next while giving our order for detecting the necessity of the bridge dated 2014 is incoherent. Accordingly, communication was made to Mark Secretary WRD as the Guwahati CEO GMA Commissioner James.
I think this letter was taken into consideration in the judgment. In the judgment.
What is important here? Some 1 or 2 paragraphs.
Yes.
B. As per the report submitted by CEO GMA.
Which one? Which one? B. Okay, B.
B.
Yes. Yes.
Memo dated so and so accepted that these will certainly enhance the connectivity between the two sides and the inside locality to the internal code of the project. As per the report from Commissioner, memo dated so and so, the road connecting temporarily to be connected to the pilot and be open for public. D. As per report received from CPR WRD, that they will stand by the order of NCO so and so earlier. Hence, from the above, it is observed that necessity of the subject and enhance the connectivity with the current. Finally, next is the last property part. In view of above, I so and so have no objection. The permission is granted. And thereafter, the bridge was completed. So, bridge was completed. That in the proposed road definitely have some positive effect. Now, coming to my first round was that they have not come with clean hands, that I am trying to substantiate by various factual deliberations. Number 2, that the writ petitioner is 163. Whatever I am submitting is all part of my record. I am not submitting anything from the air. That the writ petitioner initially withhold the agreement dated
because they initially did not disclose this agreement. The debtor initially withhold the agreement
Yes,
dated 6/6/2020 between the writ petitioner and the private respondent file. However, on direction of the Honorable Court, it is ordered dated 8/2020, the agreement dated 6/2020 between the writ petitioner and respondent was brought on record by the petitioner to an affidavit. That on perusal of the agreement dated 6/2020 between the writ petitioner and the private respondent number 5, it only an explicit indicates that the writ petitioner is agitating private dispute between the writ petitioner and the respondent number 5 regarding monetary consideration resulting from a changed circumstances, change in law to deal with such situation in the agreement dated 2020 with specific clauses for provisions for modification of the agreement and arbitrary clauses. Coming to next case, Lordship, my submission is that they are abusing the process of law, paragraph 5. Fourth line, on the contrary, if it is a writ petitioner who have not approached the Honorable Court with clean hands invoked exerted ordinary jurisdiction of the Honorable Court under Article 26 of the Constitution to settle private disputes with the writ petitioner and the private party which amount to abuse of the process of law. They are praying for certiorari. So if a certiorari is to be invoked, a writ of certiorari is to be invoked, he should have some grievance and his private rights should be infringed. Now, whether the private respondent is getting 175 or 275 FAR, what private right of his is violated by the action of the GM. KMDA granted it on the basis of the factual requirements which they have fulfilled. We have given them. He also obtained whatever was there as per law. He also got 200. Later on in 2020, the law changed. So he got 275. For that, what wrong we have done as a government agency, for which he can invoke the private jurisdiction. If they have any dispute regarding the monetary consideration, whether it's 25% or 15 lakh, whatever crores, those are private disputes, and they have a redressal forum for that. Under the agreement itself, that arbitration clauses are there. So, in that view of the matter, is writ petition without there being any legal infringement or the rights of the writ petitioner, that his legal right has been infringed or violated, Lordship. This writ petition is liable to be dismissed in limit. Because the basic requirement, basic ingredient for invoking the writ jurisdiction as a writ of certiorari, they have not fulfilled. Had it been a public interest litigation, things would have been different. That 22, 21 stories building, 2 persons get injured if the construction is not correct. If the road which is narrow or wide, or there can be scope for flooding of the area. All these are areas where the public interest is involved, but he is not invoking that. Whatever he is there, that the planning permission should be set aside, the NOC should be set aside, and he should be granted instead of 275, 175 FL. These are the prayers. So while exceeding this prayer, what legal right he will earn or mitigate it? Absolutely a misconceived writ petition, my submission. He has some private disputes with the other side, then they are trying to involve this honorable court under 2 minutes. It is not permitted. And as such, the reputation is not maintainable and liable to be. This is purely an exercise of the abuse of the process of the court. Now coming to paragraph 7. We have explained everything for paragraph 7.
Page
165. On the factual status. The answering component dates state that the special project is by the of the year 2008 based on the report of 28/12/2013 on a pick and choose basis without referring to the entire report and its conclusion. The answering deponent further states that the report dated 15/12/2013 was submitted to the Deputy Commissioner Kamrup by the answering authority in the year 2013. As per the actual site condition on the date of inspection and to indicate that the status of road at that time. When the bridge across Borodo River was not in existence and the road and its surroundings were not fully developed. The road width are shown in different chain areas along Kurunnagar Byland that as per clause 58.9 D of new revised building bylaws of Guwahati Metropolitan Development Area 2006. The minimum road width required for apartment above 12 meters height is 8 meters and the maximum allowable FAR is 200 for road width 8 meters and above. The petitioner was entitled for maximum allowable FAR 200, but Common Technical Committee allowed FAR 175. Initially, as the bridge was not constructed, other unfavorable of site conditions, pending court cases, etc. The site inspection report meetings of the Common Technical Committee road width and the proposed road width are mentioned as 8 meters and 8.5 meters, respectively in connection with the building permission proposal of the and the affair was allowed according as per the provisions of bylaws of 2006. However, maximum allowable FAR was 200 was allowed in the NOC by dated 3/8/2018 based on prayer of petitioner dated 25/9/2018 after construction of the bridge and improvement of overall site conditions. So initially 175 of 2009 and 10, 2017 also after the construction of the bridge also 175, but later on we filed a fresh application of 25/9/2018. We got it in the month of November 2018 FAR 2. The answering deponent takes the opportunity of being on record the order dated 54/2014 passed by the DC. I have placed all these things shortly. Wherein the petitioner himself submitted a letter of 7/1/2017 addressed to the ATC, claiming that the average road is 8.5 meters. The relevant portion of the order is okay. We have put it there, but I have already. Now coming to next page, second paragraph. As such, the present petition of the letter dated 7/1/2014 stated above by the petitioner himself regarding the width of the road 8.5 meters. The petition has no legs to stand. It is apparent that the petitioner is changing the stand as the width of the road before different authorities would with its own convenience. It is apparent that the petitioner have not approached the honorable court with clean hands and the other aspects altogether motivated resort to the Constitution, which amounts to abuse of the process of the court. Coming to paragraph 10. The answering deponent stated that the planning permit dated 10/9/2020 pursuant to application dated 1/9/2020 by respondent number 5 was issued by the answering deponent. The answering deponent stated that the pursuant to application dated 1/9/2020 by respondent number 5 this permission was considered under provisions of Guwahati Building Construction Regulation bylaws 2014 as amended 2020 notified on 5/5/2020. Thereafter, the answering deponent issued planning permit on 10/9/2020. The planning permit 10/9/2020 issued by the deponent was as per the law prevailing at that relevant point of time, taking into consideration the average road width as 8.35 meters. That the planning permit by dated 10/9/2020 was issued by the answering authority pursuant to the recommendation of a 3-member committee's report. The 3-member committee sat on 5/9/2020. The committee completed the average width of the road leading to the project of respondent number 5 and upon duty considering the existing synergy of the roads and overall connectivity of the project site, large variation of the road width at different stages, the existing needs and as per provisions of building bylaws 2014 amended in 2020. Anything above 8 meters to 50 meters, the plot area more than 10 vehicles will fetch a FAR of 275. As per law, the average road width of the project was calculated 8.25 meters. Accordingly, FAR
FIR 75 was allowed in the planning permit. This implies that the road width of 8.01 or 8.35 is the same FIR 275 as in the incident case. It is pertinent to mention that FIR of 200 was allowed to the institution by NOC dated 11/2018, which the institution was entitled for road width of 8 meters and above, with plot area 4 kathas that gain is missing in because also as per provisions of the new building bylaws, as per clause 58.9.3, whereas earlier road width was 6.6 meters or more or less than 8 meters, apartment of 12 meters height may be allowed to the maximum of FIR 175. Here, in case the height of the building allowed in various the bylaw 2006 was more than 12 meters in height, which establishes the fact that the road was always considered 8 meters. But initially, FIR was restricted to consideration of unfavorable site conditions, including not construction of the field, which was the precondition of the NOC and pending court case. The average road width of Surunnagar by length measured at 8.5 is on the site conditions for the development as per provisions of the bylaws and that any road with above 8 meters pitch, the same FIR of 75 as per the court. Both the therefore my lord is have a look at the report which is annexed at page 188.
59.
The 3 members report at
559 report.
Yes, 59. Yes. A proposal for group housing residential apartment building comprising of 5 blocks submitted by MS Protect was received online. However, due to the large size of the proposal could not be processed online as the auto shared software failed to run the program and halted time and again after certain limits of process. This has been examined and certified by Smita Sharma of MS Protect, 2020. Thereafter, the applicant submitted third copy of the proposal for further scrutiny and office of the planning permit. In the meantime, Chairman KMK had ordered a 39 constituted members committee with the following members for scrutiny and recommendation of planning permit over 10 meters of plot area. So these are the 3%. The committee examined the aforesaid proposal and visited the site on 5/9/2015 to study the grounds. Measurement of the road was taken by Bharat Mondal and Kurundas Mondal of GMT and various sections of the road. The width of the road Kurunnagar by length at the last junction point leading to the plot in front of the plot and the point where the road RS follows. Entry point near number 8.05 meters in front of the plot 12.50 meters and minimum width that is the pitch 4 meters. As per Guwahati Building Construction Bylaws 2014, Para 26, the average road width is defined as follows. This is quoting from the law. The width of a street road means the shared average width of the existing carriageway and path and drains on which the building or pumps abuts. The minimum width of this existing and proposed width described by the authority will be taken for calculating maximum permissible height of the building. The average width shall be computed by taking width of the road at the last junction point leading to the plot in front of the plot and the point where the road is minimum. In cases where the width of the is not greater or uniform all along the road of the road, provided that the minimum road is available at entry point in front of the plot and some other. On the basis of the above provisions, as the road width is not regular, the average width of the Surunnagar by length found as under. Average road width 8.05 plus 12.50 plus 4.5 divided by 8.35 meters. As per bylaw 24A1, the wider road, I placed 26 and 24 already. As per As per bylaw 24A1, the wider road is to be considered for determining building height and other regulations. Provision is as follows. Provided that the authority shall prescribe different front and rear setbacks, considering space required for widening of road and minimum space required. In case of building above for more space, the wider street shall be considered for determining building height of the other. Front setback of all categories of building shall be as per 24. As there are two other roads, one at the rear side north end of the plot, Kawali plot, 5 meters wide, and average road width of per side, both linking Bagor main road and the proposed site is found to be 4.67 meters. The wider road of proposed number by land is considered for the proposal. All along this road was only considered from 2009 onwards. Next bill. Other salient features of the proposal are total area as per document is 17,430 square meters and as per site plan 974.30 square meters. Ground coverage 30%, cover area proposed FAR is so dwelling unit is 65. Their dwelling unit was much more low. Now it has been reduced. Then the blocks. Now coming to the next phase. As per amended building bylaws 2020 notified on 5/5, the applicant is entitled for a premium FAR of 275, base FAR of 1, coverage area 40% as the road is more than 8.0 meters and plot area is more than 10 meters. As per bylaws 28.1 of the building bylaws, the maximum height of the building is provided as follows. Building height shall not exceed 1.5 times of the width of the road plus the front open space. Therefore, the maximum eligible height of the front block A shall be 1.5 into 8.5 plus 1.47 shall be 35.7 meters. Similarly, other blocks height of the buildings are examined and found within the permissible limit. Coverage of the footprints of building blocks are found to be 30.12%. As per National Building Code 2015, Part 3, Clause 2 coverage shall be calculated on the basis of the whole area reserved for group housing. In instances, the area reserved group housing of all the floors comes to 30.12%. Clearance of MEOF, Assam Groundwater Authority, suggestions from FPSA, proof checking of detailed structural design and drawings by SCRP to be done prior to commencement of the construction. Other provisions such as 50% of the area to be kept exclusively for recreational areas, RWH's provisions for different as per right of person to be kept are to be made. So this report was given and this report was not to challenge at any. Coming back. Paragraph 19.
Let us see the prayer once again.
Okay.
Let us see the prayer once again.
Here.
Let us say
One circular shall not be used for setting aside and passing the GMT permit 10/9/2020 can exert 7C. GMC permit dated 19/9/2020 to extend the scope of the group of finance has been taken to be 8.35 dollars and surely the entitlement of FAR 2.75 better on the 5. This is for clear that permits are Sarsiades taking aside and passing the decision of the respondent of the plan FAR 275 to the R5 instead of FAR 170. 3. Amendment shall not be directed to the respondents not to give effect to the GMT permit in 9 and GMC permits 19. These are the 3 things. So they are happy with the report otherwise. Nothing but a bargaining tactic in my humble subject. Paragraph 19.
DMK and all government agencies are tagged into here.
Paragraph?
Paragraph 19 of page 170. Third line, the answering deponent further said that the petitioner never applied for fresh under the provisions of bylaws of 2014 as amended in 2020 notified on 5/5/20. If he had applied, he would have got the same thing. The writ petitioner went on revising NOCs under the provisions of building bylaws of 2006 with modifications and additions of the project could not be executed within the stipulated time. The writ petitioner had already availed FAR 200, which is maximum FAR entitled for root use of 8 meters under the provisions of 2006 bylaw. The bylaws of 2014 was amended in 2008 to notify on 5/5, and the corresponding FAR allowed for road of 8 meters and above 70. The answering deponent again reiterates the statements made in the paragraph statement. Paragraph 27, 175. The answering deponent made to submit that upon renewal of MOU 9/11/2019 and agreement dated 6/6/2020 conjointly between the writ petitioner and R5, it is apparent that the issue agitated by the writ petitioner before the honorable court in the present proceeding is a private dispute between the writ petitioner and the respondent 5 arising out of changed circumstances owing to change in law, which was not taken care of by specifically by MOU dated 9/11/2019 and agreement between them. Now cannot resort to invoke Article 56 of the Constitution of India for instance of a settled private by abusing the process of for the on the soldier of the answer. And our whole stand was known to them. Is $129. This also they have not challenged. The part of the resolution annexer 100 annexer 60. Dated 14 December 2020. Issued by the Chief Executive Officer GMK and was addressed to Onur Soika, MD, McMahon. Your petition regarding request for information dated Wednesday. In inviting reference above, I would like to state the provision for the April. The planning permit was issued to protect housing dated 8/9/2021. After cancellation of the building permission earlier to MD McMahon 11/2018, wherein the road width of Rupnagar byline is mentioned as 8 meters. From available records, it is evident that based on your request at that time, it is 25/9/2018. The FAR was allowed as 200 as against 175 FAR allowed earlier. The NOC was issued by DMK dated 3/11/2018. It is admissible only in case the road width is 8.00 meters or more as per provisions of the device bylaws of for Guwahati Metropolitan Area 2006, under which the building permission was earlier issued. Planning permit was issued to MS Protect as per provisions of the Guwahati Metropolitan Area bylaws with the road width and allowable FAR to protect housing was determined as per the provisions of this bylaw, that 2020 bylaw, based upon the on-date site condition. You are also informed that the earlier revised proposal of Netballer approved in 2018 was issued on the basis of the proposals of new bylaws, building bylaws of 2006. Considering this as a revised proposal for earlier approval given under the same bylaw, whereas MS Protect housing was issued in after the plot was transferred by
earlier. Because it is not 14%. So this is our scandal. So whatever we have done is as per the law prevailing at the relevant point of time and also after doing the ground reality check. At the road pin below 8, that you not have got 200 also. If it is beyond 200, 8 point, so he got 2.75. So whatever is there as on date, as the law applicable date, Protect got that FIR of 275. He got the same in 2018, 200. He got 175 in 2009 and 10, as well as in 2007.
In the, Mr. Sekia, in the MOU as well as the deed of agreement, what is the FAR mentioned? 200.
On the basis of 2018's permit, that was indicated.
And in the prayer, he wants a decrease to 170.
That is why in Assamese we have Nidor Napkate Potini Jatra. That is happening. Suppose the project goes back to him for some reasons. He got 200. For his own prayer, he will have to take after 1 second. That is the bargaining question. That is why I'm.
Let us see the MOU again. For a
Very interesting. This morning I did the MOU for that purpose. The MOU, I presented the deed of agreement.
Even MOU will have that, I think. We have it at.
Paragraph 32, page 155.
No, no, in the MOU.
MOU. It is more elaborate in the deed of agreement.
Where also will get.
Here 15 also what is can be seen. In 15, paragraph 15 of page 52, the date is not mentioned, here the date is also mentioned.
Just a minute.
Paragraph 50, may I read?
Just a minute, just a minute, just a minute. You are in which page?
Page 50 of the
52.
paragraph clause 15 of the MOU.
Yes.
The first party permits the second party to take possession and start the work on the date of signing of this memorandum of understanding. And the second party will take care about the NOC permission being the that this protect will take care of.
Yes.
Further, first party has no objection if the second party is or at least or apply and obtain place permission or remove or modify the existing NOC as per bylaws, and in such event, the benefits therefrom will be available only to second party. That both the parties agree that the above 35% of total saleable area is as per FPR allowed in above paper present NOC from the company. So present NOC was of 2018 at that point of time. After this, they have applied because of November 11, November 15 of the date is 9th November, page 40. 9th November 2019. So the impune planning permits and impune NOC are dated 10/9/2050 and 19/9/2050. So this is of the previous year. In such event, the benefit therefore will be available to the second party. Both the parties agree that the above 35% of total saleable area as per the FAR allowed in above paper less present NOC received from the competent authority shall be given to the first party by the second party. And no further area share will be given by the second party to the first party, even if the second party gets additional FAR under provisions of law. This is one part. Now coming to paragraph page 155, paragraph 30. Now paragraph 32, page 155.
Yes, please.
That both the parties agreed that above 1,75,345 square foot saleable area is worked out reduced based on the above referred existing NOC that is EMDS so 3/11/2018.
18.
That is 200 ampere. Received by the first party from the competent authority prior to signing of this agreement, which only forms the area consideration to be given by the second party to the first party, and no further area share will be given by the second party to first party, even if the second party gets additional benefit to construct further area in any name or manner whatsoever, under present provision of law of the competent authority. So the present provision of law has been changed 1 month earlier of this memorandum of agreement. But when the memorandum of understanding was signed in November 2019, that amendment did not take place. In the interim, between that 7 months period, the law changed. But it was known to them. With their eyes wide open, they have accepted this. No coercion, they themselves have taken.
Okay.
And there is a provision also under the bylaws, that by giving away my land, by widening the road, I can get additional FR. But those conditions, those provisions were never applied. That is why, in case suppose that in future I give up 4 or 5 bighas of land from all, I can get more FR. But for that, I have to part with my property with the public. That provision is also there. Chapter 4 of the Guwahati Building Construction Regulation 2014, clause 121
Of the?
of this Guwahati Building Construction Regulation bylaw 2014. Bylaw 121 says additional FR for widening of road provisions, improvement of junction layout, public support and
Kindly give the relevant.
It has no relevancy, but what I am trying to say, if one person wants to increase his FR, he can give his own land. But that was not done. So that 4 meters also, which he relinquished at one point of time. There is nothing illegal on that. It is not irregular also. It is permissible under the existing law in force.
Okay.
So the factual parts, I hope I have placed all the relevant points which for consideration of this honorable court. So my submission to sum up is also pretty clear that there is no personal or individual right being infringed of the legal right. There should be a damage on his legal right. That has not been caused. So no cause of action to invoke the jurisdiction of Article 226 or to attack the provisions of the deed of certiorari. He has not placed the facts in a bona fide manner. In 4 situations, he said the road with different measurements. 8.5, 8, 7.5, and 6.57. These are the 4 figures he has given in his petition. Paired with the reply, affidavit reply.
Yes.
This this petition, Lordship, in my humble submission, is not bona fide in nature because he himself is trying to get an order from this honorable court, which will be detrimental to his own interest. That's for the same property, same project, he obtained 200 FR. Now he is praying that it should be given 175. Change of ownership will not change the law or the facts. Law is constant from the point of view that law can be changed, but with the same facts, same factual matrix, law cannot be changed at a relevant point of time. So what he is trying to say that 175 was the correct according to his own assessment, that it should be 6.57. His own calculation in paragraph 13 of I read it. So that means he himself has cheated the government or the agency. So when he is trying to point fingers at others, that others are committing mistake, others are after 150 crores, others are giving different versions. What he is saying, he is trying to build up his case on the basis of the report of 2013. In which report it was very clearly said that the road is not 8.5 meters. But that was the situation at that point of time. And when he obtained the two permission of 2009 and 10, the road width was given as proposed 8.5 meters. Absolutely correct, Lordship, because while considering the bridge was not in existence in 2000. The bridge came in 2016. And thereafter, he also got the benefit of getting 200 FR in 2018. So he is trying to put around every agency, to the deputy commissioner, other agencies, DMDA, DMC, and he is trying to stay danger with this honorable court also. Dangerous game is. So for his personal bargaining with the other party, Lordship, he is trying to utilize or use this honorable court, which in my humble submission is totally unacceptable, impermissible. So when he took 200 FR, he cannot say that the FR was wrongly given. Now he cannot say that the other party should get 170. When he is under the changed circumstances, changed law, he is entitled for 275, and there is no infirmity or favoritism on the part of GMDA or GMC in granting him 270. If we had not given him, their right would have been violated. So FIR 275 is entitled under the new law. His whole submission is that 8.535 road width was given by a 3 members committee in a haphazard way. We have placed everything before this honorable. He himself said that the road would have been 8.5 if the bridge is constructed. So he is changing his own. And on top of that, the report which was given by the 3 members committee constituted on 3rd September 2020 is not challenged. Neither the constitution of the committee is challenged nor the report of the committee is challenged. According to him, the constitution, the committee cannot be constituted. The committee is illegal. All these things he has said in the pages, but there is no prayer for sitting aside the committee or the report. And on top of that, my submission would be not appeared in a children's way. Section 12 of the GMD Act of 1985 very clearly empowered the GMD to constitute any number of committees as per the requirements. But the committee should have 3 members, minimum and maximum 7 members. And they should be having the domain expertise. So the persons who are part of that committee all are qualified and domain experts in the area. And that committee was not constituted for Mahesh Mallar or for Kotem. That committee is still working. It has been from 3 members, now 5 members, and they are inspecting and giving reports in case of any building permission or any planning permission sought from GMK or DMK or GMK, where the land area is more than 10 acres. So the big size projects, this committee is in operation.
The other day, Lordship was there, whether a trace inspection can be done. My submission is that the report is not incredible. If Lordship has some doubt, then definitely Lordship would like to do it. But all the sides are saying, even the repetitioner is saying that the road width at most of the time is beyond 8 meters. Our report also says the same thing. 2009-10 report also says the same thing. So there is no question of doubting the report. Had there been any doubt, I definitely would have welcomed. But he himself is giving 4 different versions. He took advantage of 8 and 8, more than 8 and 8.5. So there is no point of him casting any aspersions on the road width or the findings of the committee. So in my humble submission, Lordship may not be this to explore that option. And if at all any party is agreed, it is the public in general, that is not the right proceedings. Lordship. He could have filed a public interest. But those were not pleaded, so therefore, Lordship, here it also not be based on the pleadings which he have pleaded, because he has said that with a big foundation which he wants to be building starting from, but today from that piece of understanding, very clearly say, expert from Calcutta at their initiative were brought, and before handing over the project, every minute inspection was regarding the construction, regarding the stand, regarding the trace construction to be done. And he initially got permission for 2 blocks. Now there are 5. So rest the other side will be public here itself. But from the records available to PMC for the purpose of obtaining planning permit or from PMC regarding grant of NOC, I am making my submission. And other submissions are based on the pleadings which they have forwarded. And if the authority for giving a patient care, this is my humble submission. There is absolutely no material for interference, and this requisition is liable to review with cost of. Highly appreciate.
Yes. Mr. Das? Oh, yes, yes. Where is he? Huh? You can make your submission. You can complete your submissions today.
Also, I'm just hearing this matter. Only one paragraph I have seen, there one paragraph here said, I am minister, these are his sons. But that is 2021, I became minister. And 2020, then permission was done. Permission granted, then again he said that I was the chairman. Now there was a chairman, but there was a committee which was formed, which my lordship was the head. What is my role? And the committee is the committee has given a report.
You will not have an influence about the committee.
What?
As the chairman?
Then your lordship has go to a doctrine of biasness, all those has to be brought before your lordship. That's why I'm saying my lord.
That has been pleaded.
Sorry.
That has been pleaded.
What?
That it is because of your influence.
No, they have taken a different stand. One stand they are saying about the minister. Subsequently, they have changed the stand. Because they said one chairman. Chairman was prior to that. How can I influence, right? There is a question of influence. But I have
Chairman or chairman, as a chairman, you will not have any influence over the committee.
My lord, with great respect, this repetition first of all is not petition. My lord, this repetition is not pensionable at all. What I have been hearing before this court, what is the repetition filed? Repetition has been filed. Now the prayer which has been made is that it should pay permission which was granted.
You can make your submission, we'll record the submission.
No, my lord, I have to go. This is what I just was. I have to go through it. Those your lordship said.
Then today we thought they will hear you because they've given sufficient time. We thought of completing the respondents part, then maybe Mr. Chaudhary would give his rejoinder.
That's why I protect. They have to, because there is a
tie-up which was made up between them. So I will just smile place before your lordship, let them finish.
But Mr. Das, you'll have to meet those submissions regarding influence bias.
But one thing,
Simply
my
saying that I did not
There-
have any role
no,
may
that's
not do.
No, there are two things. Tomorrow, if your lordship, that there is this petition is not pensionable, then for an
That's a
example-
different, no, that's a different,
No, that's
different
why-
context altogether.
No, that's a.
That part has been taken care of by the authorities.
No, my lord.
Learned AG has made elaborate submission, the role of GMD. But while taking the decision, in the decision-making process, did you have any role?
I
On that, you have to,
I will, my. But your lordship has to look into the writ petition also.
oh,
That
definitely.
also I will say my role. I will definitely give a reply to my role. But definitely I have to like to give a
See,
comment.
Mr. Das, while structuring the petition, they have taken many grounds. One of the main grounds is your part in the decision-making process, the allegation. You have to refute that, and how you refute is up to you.
I have refuted, I will argue this matter. Okay. But I like to also argue on the pendency of it.
You can,
Yes, I will argue on the pendency
you
of it.
can. You can, you are a implicated respondent, you can
Yes.
definitely argue.
And what I have told that he said they have arbitration, they have resort to arbitration. And what I have been hearing.
What
for
is the,
last-
what is the dispute in
No,
the
dispute
arbitration?
is- My lord, now, what is, my lord?
No, what is the
share-
dispute? What is the,
shares- Shares will be definitely shares. If your lordship, what I am hearing from AG, my lord, clause 15, what is clause 15 they want now? Clause 15, that's the dispute. My lord, my part, forget for a moment, my. I am just commenting on what the argument that has been advanced. What is clause 15? They have come up with clause 15. One hand, they are saying, they were very happy when FAR was given to them up to 200. Now thereafter, in 2020, there was a bylaws. In bylaws, it was 275. Now what is clause 15? They say. Clause 15 said, no, we are not demanding. Whatever shares, we are happy with that share. Thereafter, no, we will not claim. Today, whole issue is that this is what, my lord, I am just hearing it, subject to correction.
are you taking up the issue of estoppel?
That's my lord, that's what I'm saying. Let's see, my lord.
By the agreement, they are legally stopped from raising the
My
issue.
lord, my role is, I don't mind what language, but I just want to edit. I will have to edit. My lord, these are all.
Okay,
my lord,
but we
these
have to,
are-
we want to finish off this matter very
Yes.
soon.
my lord, These are all private. business.
Mr. Batra, when is your senior coming? Fifth, কিন্তু আমার second half interview, second number. But fifth, we have to take up early because the next week, this court probably would not be sitting in the second half. All the 4 or 5 days. There are some interviews scheduled. On 5th, Tuesday. So if there are any motion, immediately after the motion, I'll take up.
My lord, I just look quick. Give me a permission of half an hour, I guess.
Fifth, you completed.
I
Fifth,
just-
will hear Mr. Pathak.
Yes, I will just start on fifth.
You are for Mr. Batra for whom? Who are they? Oh, you are the private respondent and you are the, okay, you newly implemented. Okay, Mr. Pathak, I think will have a role to play. Okay. Fifth, Mr. Chaudhary will be here.
Court onwards, Mr. Chaudhary is in Supreme Court.
I think that's.
Okay, fifth, we'll complete this, your side,
Just,
and we'll fix for a rejoinder immediately on his coming. Okay. The learned Sri D. Sekya, the learned AG Assam, appearing for the GMD, has concluded his submissions. Full stop. On behalf of 3, KP Pathak London Senior Counsel, appearing for the respondent number 5, as well as 3, Leaders London Senior Counsel, appearing for the respondent number 6, pray for some accommodation for making their submissions. Full stop. As agreed to by the Learned Council for the parties. List for admission on 5/12/2023. Full stop. Liberty is given for making a mention for upgrading this matter. Mr. Sankya, Mr. Sankya. If you can kindly instruct Mr. Bora to extract those pages which you have referred in a small bunch. I think you have referred to around maybe maximum 20-25 pages separately, but the pages will be, numbers will be the same.
Sure.
Okay. Kuntu? Oh, Madam, your case, what is it? Some urgent matter?
Meet with the lordship. This is, my lord, the company applied for building permission, my lord, in the year 2011. Thereafter, my lord, the high-rise committee approved it, and my lord, now dispute is regarding, my lord, June. Earlier, my
Regarding?
lord,
What is the dispute now?
dispute, my lord, they are disputing the DAG number, pata number. DAG number has been changed. First, I'd like to place, my lord, annexure on page 15.
Mr. Nayak, you for the respondents.
Here for GMC and GMD, he is appearing, my lord.
Affidavit filed.
If it file. Annexure on page 15. The chief executive officer has written to the woman and.
Now, what is your cause of action? Why have you come to
Cause of
this court?
action, my lord, that we have applied. It was, my lord, thoroughly, my lord, they have inspected.
Okay.
The
Then?
zoning certificate was issued by CEO GMD. One reconfirmation was also issued, my lord, and the high-rise committee approved. At that time, my lord, FIR was, my lord, that a permission was given for G+8.
Okay.
Thereafter, my lord, 2014, it was approved, my lord. But, my lord, due to some other reason, my lord, the project could not be made at that time. Thereafter, again, they have written in 2017 to file a fresh on some
Okay. Then?
drawing and other thing.
Okay.
So thereafter, we have presented and deposited the money also in the this year, my lord, in the month of April. Thereafter, my lord, the it could not be processed, my lord. They are disputing, my lord, the DAG number has changed. But I have obtained a certificate from the
Yes,
circle
it's
officer.
yes, Mr.
DAG number.
Now, are you disputing on facts?
It is in fact the present location, DAG number 160. It matches with DAG number 26, not with 16. That is in my what point is it?
One say earlier, whatever inspected, it's bounded by boundary wall. So, my lord, I have page 35-year-old for lordship.
What is your explanation towards changing the DAG numbers?
DAG number time to time, my lord, it is changed, my lord. The
No,
circle
we
officer.
are not on that. We know that DAG numbers, pata numbers
Some
can change.
Yes.
But is there a change in the plot?
No, my lord. Same plot.
he's saying
now,
that-
now, my lord,
He's saying that the new
my
DAG
lord.
number
Let me
pertains to
complete that.
26, not to 16. Your
26 is, my lord, pata number, not DAG number. DAG number is 16. According to them, DAG number 16 falls within the residential zone. Accordingly, the CEO has certified, my lord, and written to the commissioner GMC, that it falls, my lord, under residential zone. It was reconfirmed again. Again, my lord, the commissioner GMC written whether it falls under residential zone.
Yes.
Then he, after 2 months, again he reconfirmed, yes, it falls under residential zone. And accordingly, that proposal was approved and recommended by the, my lord, high-rise committee, which, my lord, the committee said. Thereafter, the project was in 2014, month of August, it was done. Thereafter, for some time, my lord, it could not be
Now the
pursued.
new DAG as per you falls under what zone?
Eco-friendly zone.
So far as our district.
And my lord, let me give me only 2 minutes, my lord. He will reply, my lord. He will reply, my lord, otherwise the facts will
No,
be
no, we have
difficult.
more or less understood the facts. But
Yes.
if there are factual disputes,
Factual dispute, no, my lord.
how do we
Annex of
reconcile?
page 34, my lord.
34.
Regarding the tag number, I have obtained a certificate from the
34.
circle officer. Page 34. Translated copy, my lord. It is hereby
Yes.
certified that the records available and as per report of the allotment on the application district control line number Khanapara village Karaman, patta number 8 old 45 new and dag number 16 has become now 162. So they are disputing, my lord, 16 falls in residential zone and 162 does not fall in residential zone. So whose mistake it is, my lord?
Yes, revenue department who is appearing.
And thereafter, my lord, the map I also annexed, my lord.
Yeah,
that
but
map was
Mr.
not
Nayak,
certificate.
we'll
It is a
definitely,
Basti land,
one second,
copy of
one
Jawabandi.
moment. We'll definitely consider your version. And we are thinking if factual disputes are concerned, what to do. But nonetheless, this certificate at page 34, it refers to DAG number 16 as old and 162 is new. If old DAG number 16 is false,
For that clarification.
where is the, yes,
Possibly take the last step by.
page,
Uh,
page.
Yes, that.
55. Yes,
Also, it was executed. Not for the.
55. Okay. Yes.
But this is the plot, not condition.
In mark portion. This is 160?
Two.
Yes, 162.
Possible comes, yes.
Yes.
Possible say another plot, one mark.
Red, it's red.
Not pink one, this is the orange.
Orange one is what? 16.
This is 20.
26.
This is in our position. And 16 is above 14. That pink number. That is 16. So that 16 is residential. But 16 is not in our possession. And 26 and 162 is the same. But if it is any correction is required in the map, that can be done by the survey or legal department.
But that map is not having any date and my lord, not certified by any certificate officer, my lord, competent officer. This I have annexed this map also, my lord. It is certified by circle officer.
What is there?
It is annexed also, my lord.
In your petition?
Yes, my lord.
Where, which page?
That is, my lord, at page 36.
36.
Yes, fine. This is the original one. I can read just.
36.
This is certified by lord, certified
In an
by the
additional
circle
affidavit.
officer. Certified by circle officer.
This is 162.
Yes, ma'am. And the earlier 16 has become now 162 because that is long back. And my lord, all this, my lord, Namzari certificate also says, my lord, that same thing, my lord. That, my lord, it is 16.
62.
In between it was 42. Now it is 162. Twice, my lord, this same, my lord.
Mr. Nayak, at page 54, the orange portion, it was initially 26,
That orange portion is 22.
which you say is which you say has now become 162.
Yeah.
Not 16.
The status. It's your property, so status from. Tag number 16 is the take portion. Take portion is the residence. And this 26 lot. The same plot once. Even then also lots because.
16 says, my lord, that permission is, if your lordship see the petition, my lord, permission is also given. And my lord, it does twice confirm, my lord, that it falls under and another, my lord, same pattada, same dag. They have constructed 14 stories, my lord, from the Khanapara, it's in, my lord. We are having common boundary. That is certificated as, my lord, page 16. Then again, my lord, it was reconfirmed at page, my lord, at page 19, 29 March 2011, written by the Chief Executive Officer GMDA to the Commissioner GMC. Page 19 of my petition. That after verification of new master plan, it is found that zone already mentioned in this office letter. That is
Madam,
zone
we'll do
chart-
one thing. We'll try to resolve your dispute.
Yes.
Well, let us have the views of the revenue department. Let them confirm it. The new numbering,
Land is same land, my lord. I cannot purchase another land.
obviously.
And my lord, if your lordship,
No,
Here,
what madam is saying that the initial permission was given treating the land to be a residential, in the
Yes.
residential zone.
yes,
Now you have said that that's a different plot of land. Now,
Have clarified in the tag number 16. Which plots you are in position of that one.
yes, anybody from the revenue department? Can you call anybody, Mr. Borpujari or Mr. Madam
because
Mohanto?
while in the meeting, all drawings are submitted in AutoCAD, my lord. Every inch is, my lord, in AutoCAD. It's a technically, on technical engineers are also available. Page 20, your lordship, may kindly see. The
20.
approval by the committee, 20. Yes, my lord. 6, my lord. Serial number 6, in the committee meeting. That name lead for builders and developers, so file number 7, location 7, block. LGF, EGF 11 and block Iman, EGF 7. So, my lord, it was recommended.
But it was the zone is eco-sensitive.
Here, my lord, not written, my lord, it's a residential zone. Still, they are
No, here zone
agreeing, my
is,
lord.
zone is
Zone is
eco-sensitive.
residential.
Zone is eco-sensitive. Mr. Nayak, page 20
Page 20,
of the petition.
recommended for G+8 block.
Second column.
Yes.
Third line, zone is eco-sensitive. Even here it's eco-sensitive.
Where, my lord?
Aren't you Luitpar Builders? Number
Yes, ma'am.
6.
Yes,
Location and description, second column, village Khanapara, NK, Moza Beltora, zone
Oh, zone.
eco-sensitive.
eco-sensitive, but it is written as, my lord, residential.
No, use is residential apartment, swimming pool, etc.
Hmm.
Others are zone are all residential.
But 16, they have agreed, my lord, till now in their affidavit, they have made that tag number 16 falls in, my lord, residential area. 16 is residential.
Not in the map.
Affidavit also they have admitted.
If there is any mistake or confusion in the map, that will be corrected. But our position is 26, now it is 1.
26 pata number. Tag number no. Tag number is 16, pata number is 26. Exactly correct. Right.
Correct. But your version may not be 100% correct. Page 20 still mentions your the area to be under eco-sensitive zone.
But my lord, the certificate given, my lord, and clarified.
This is your
by
document.
The,
Annexure 4 is your document.
not my
Page
document,
20.
the official document, my lord.
No, you have annexed it.
Yes, my lord. That is, my lord, in page 19, your lordship, Chief Executive Officer GMD has written to the Commissioner, Guwahati Municipal
Yes,
Corporation.
this is correct. The zone already mentioned in the office letter is correct, and the zone is eco-sensitive.
Zone is here, my lord, that residential.
No, zone is eco-sensitive.
No, my lord,
Use
then
is
earlier
residential.
letter at page 16, 7-2-2011. With reference to the subject cited above, I am directed to inform you that the site reference above concerns residential zone as per master plan and zoning regulation for Guwahati approved by the government of Assam by notification number so and so read with the Assam Gazette Ordinary so and so, correspondent so and so, so and so. So, my lord, in the affidavit also they have admitted that Dag number 16 falls in my lord residential zone.
Number 16. Yes,
Small
anyone,
district.
your revenue department.
Hmm.
Madam, you have to obtain instructions in this. You will be given a copy of the writ petition. It's a very small issue. If there is a mistake, clerical kind of a mistake, it can be rectified. But if it's a substantial mistake, then we'll have to hear this matter. You are not a party, but you take the instructions, okay? Third, MS Anseki Learned Council for the Learned Council, Anseki appearing in person on behalf of the petitioner, which the matter pertains to a building permission, and according to the petitioner, comma, due to some error in numbering the error in the numbers pertaining to the particulars of the land, comma, the building permission has been delayed. Full stop. Though the GM in the affidavit in opposition filed by the respondent number 2, GMDA,
Yes.
which is represented by Sri P. Nayak, the Learned Standing Council, comma, it is however stated that the delay oblique refusal to grant the permission is because of the fact that the area, as per the records of GMD, falls within the eco-sensitive zone. Full stop. Para. The matter can be resolved if the views of the revenue department is taken, and accordingly this court has requested, and accordingly this court is of the opinion that such views be taken. Full stop. Para. The petitioner is accordingly directed to serve a copy of the writ petition to MS G. Hazarika, Standing Council, Revenue Department, to enable her to obtain the instructions. Full stop. Let this matter be listed when? Next Friday?
Thursday. Thursday. And what do you like?
Next Friday.
Next
1 week.
Friday.
1 week. This is your copy.
Yes, ma'am.
On Friday next.
This can be part of record, my lord, when I'm submitting.
No,
the
no, you have this with
mandatory
you.
copy.
You can hand it over on the next
Yes,
day.
ma'am. And here also, in between from 16, in between, my lord, it has become 142. Now 162. How can I help? Because of the 20 years back, it was, my lord, 16. Then it has become 142. Then, my lord, now it is 162. So it keep on changing, my lord, tag number, pata number, according to settlement.
सब ठगी गलत देखी हाँ ये तो क्या है item 10 implement non-appears for the applicant on call. Madam Chaudhary, you're for? IA, implement. Why don't you come and you are for whom?
I'm for the read petition.
Madam, you place your matter. What is the application? Yes.
My lord, this interlocutory application has been filed by the Lanka Gurudwara Prabandhak Committee and Lanka Sachetan.
You want yourself to be included.
Yes, Lord. Sikh Nagarik Mancha.
How are you connected?
My lord, they had protested to the grant of the IMFL in the on license to the petitioner without they have not taken into account the rules enumerated in Rule 289, 2 of the Assam Excise Rules. And so
What is the cause of action in the writ petition?
they are in fact aware of it. The writ
No, what is
petitioner-
the cause of action in the writ petition?
The writ petitioner, my lord, in para 4, para 8, in fact, had admitted to the fact that the local Gurudwara, Guru
No,
Sikh-
madam, we are not on your locus. We
Yes.
are asking what is the cause of action in the writ petition? Where have they filed?
they filed praying for lordship.
Yes, what is your grievance?
I filed the petition paying for the and pawn shop, which was closed by a verbal order by the respondent of excise
Respondent.
for that due to the complaint filed by Gurudwara and Sikh Sachetan Nagarik Manch.
Okay.
But my lord, interestingly, they have filed this IA. May I take my lord to para 4 of the IA?
Are you objecting to the implement? Para 4, yes.
Para 4, the applicant state
Yes.
that as stated above, the applicant Lanka Gurudwara Prabandhak Committee, Lanka, District, Nagaon, Assam, and Lanka Sikh Sachetan Nagarik Manch.
Yes.
You have objection as are renowned social organization of the locality, having its own statute and pivotal role in religious conflict.
Now, what is your name? What is your, Mr. Council, what is your name?
S. Nandi.
Mr. Nandisi, you have admitted that the impugned action which you are challenging in the writ petition may be an outcome of some complaints lodged by the present applicants. So there, giving them a scope of hearing will not.
No, my lord, yeah, we have filed this petition against the excise department.
Yes.
Because excise department has legally considered their active. Why they are not? They cannot be implemented. Is that a rule? They have stated that taking into account the conditions laid under 259 subclause 2. Now, my lord, what?
Mr. Nandi, we are not going into the merits. We just want to give them a hearing in the adjudication of the matter.
No, my lord, they are beyond 75 minutes.
Those are matters we take into consideration. Whether they have a locus to challenge, to raise the objections. But the impugned action is an outcome of their complaints. You should have made them parties. Mr. Gogoi, why are you objecting? No, see, they are admitting in the writ petition that there are complaints by these present applicants. What is there to object? This is implement. Heard MSB Chaudhary, learned counsel for the applicants who by means of this application are seeking implement in the connected WPC 3291 of 2023, full stop. Para. The cause of action in this writ petition is a closer.
My lord, you filed a
No, not required. We reject your prayer. The cause of action in this writ petition is a closure of an on shop.
Yes, Lord.
On IMFL off or on?
On shop.
On
On
IMFL shop of the writ petitioner. Full stop. The said closure as per the writ petition is upon some verbal orders by the excise authorities based upon the complaints lodged by complaints lodged, and such complaints are also the complaints lodged, full stop. It is submitted by Ms. Chaudhary that it is the applicants who had lodged the complaints, and therefore they may be given an opportunity of hearing. Full stop para. Sri Nandi, learned counsel for the opposite party petition, has however objected to the prayer for application implement and has submitted that written objections would be filed. Full stop para. Sri D. Gogoi also heard Sri D. Gogoi, Learned Standing Council, Excise Department. Full stop para. Where is that statement in the writ petition regarding the complaints?
Lordship at para 8.
Paragraph
8.
page
8. Page 11.
In paragraph 8 of the writ petition, a specific averment has been made that it is on the complaint of the applicants that the impugned action has been taken. Full stop. For ready reference, the averments made in paragraph 8 of the writ petition is extracted here and below. Full stop para. Though the learned counsel for the opposite party writ petitioner has prayed for time for filing written objection, considering the specific averments as quoted above, such a request is declined. Para. Considering this court is also of the opinion that by the present application, the applicants are only seeking a scope of being heard at the adjudication of the writ petition, which is an outcome of the complaints lodged by the applicants. Full stop. In view of the above, the IS stands allowed, and the applicants, namely so and so are implemented as respond number
7 and 8.
7 and 8.
8 and 9.
8 and 9. Full stop. 8 and 9. 8 and 9. Full stop. The IA accordingly stands disposed of. In the main WPC, who will file the amended? You file an amended cost title only on the in the WPC. You write in the connected IA praying for implement. This court has passed an order today, that is so and so date, whereby so and so has been implemented as respond numbers 8 and 9 and 10.
8 and 9.
Not 8 and 9, 9 and 10. Oh, 8 and 9, right. 8 and 9. 8 and 9. Full stop. Learned counsel for the newly implemented respondent 8 and 9 would file. Who will file? You will file. It's your petition. Learned counsel for the writ petitioner, Sri Nandi, would accordingly file an amended cost title to the registry within a period of a week. Full stop. A copy of the writ petition may also be furnished to MS Chaudhary, learned counsel for the newly implemented respondents 8 and 9. Okay. Yes, item number. IA4. Who's the council? Bigo Goy. MSD Das. MSD Das. None appears for the applicant on call, whereas Sri N. Upadhyay is present for the respondents. Full stop para. In the interest of justice, list after a week.
Wait, please, Your Honor. The impeding person is at page number 4, Madam. Hitesh Kalita, Madam. Here, respondent number 4 has retired in place of which this new person has to be.
What does he do?
Well, he's a retired chief engineer.
You want to make the retired chief engineer a party?
No, Madam. This Hitesh Kalita, Madam, 4 has retired. Now,
No.
this person, Hitesh Kalita, is the person who has taken the charge
As
chief engineer of the.
chief engineer.
Chief engineer.
Have you served him copies?
Yes, my lord. We have served him with a petition, my lord. That is at annexure E, page number 10.
Okay, heard. Sri H. Betala, Learned Counsel, for the applicant petitioner, who by means of this application has sought implement of the new incumbent holding the post of
Chief engineer,
chief engineer,
Assam Urban Water
Assam
Supply
Urban Water Supply and Sewerage
Sewage Board.
Board. Full stop. Para. The Learned Counsel has referred to the communication dated 26/7/2023 issued to the new incumbent, requesting compliance of the order in question. And even thereafter, no steps have been taken. Full stop. Para. Considering the above aforesaid facts and circumstances, the instant IA is allowed and Sri so and so, नाम पूरा लिख दीजिए, पूरा details भी लिख दीजिए, is implemented as respond number
7, my lord. 7.
Full stop. IA according to stands disposed of. In the contempt you write, in view of the order passed today in IA 3381, order passed today, that is date. In contempt case 21/20, whereby Sri so and so, Pura Chief Engineer Pura Dalsi, the new incumbent is implemented as party respondent, Sri Betala, the Learned Counsel, for the petitioner may file amended cost title. Full stop. The Learned Counsel is also required. Amended cost title. Full stop. Let notice be issued to the newly implemented respondent by registered post with AD. Steps be taken by Monday. Yes.
Bibliography.
Again, 2016.
Yes. What are these?
Lordship is the industrial subsidy matter.
We can hear this.
Lordship, he was on the last occasion directed to take instructions and file
Mr. Kolita,
affidavit.
can you hear this?
Lordship,
Small matter.
Three matters already amounts in paying. The only issue remaining is that as far the interest is concerned, whether the late payment interest they are going to get interest or that matter is pending with the
Supreme Court, that is
there. And another matter is 2319.
It is not listed today.
Yeah, it's
The
there.
first one, item 13.
Okay, 2319. Okay.
2319, what has happened? Also, DLC has approved the payment, but there was some miscommunication between the DLC as well as the commissionerate office. So the amount was not dispersed. So now the commissionerate office is taking
Steps.
taking the steps to release the payment. So this is my instruction.
Okay, then we'll adjourn this matter for some time.
Lordship.
And so far as the other issue of interest is concerned,
Which is already directed for keeping sanitary till disposal of SLP.
So this can be also after like
okay,
this.
heard. Three. Where are you, Mr. Todi? A to D. Your name is HOD Learned Counsel for the petitioner. Full stop. Also heard Sri A. Kulita, Learned Standing Counsel, Industries and Commerce Department, whereas Sri G. Das is present for the net fee. Net fee, full stop. Para. Sri Kulita, the Learned Standing Counsel clarifies that in this in this bunch of matters, comma, except WPC 2319 of 2017, comma, the amount in question has already been paid to the petitioner. Full stop. As regards the aforesaid WPC 2319 of 2017, comma, there was some confusion which is being resolved, which is in the process of being resolved. Full stop. Para. As regards the issue of payment of, as regards the issue of claim of interest, comma, it is submitted that the said issue is pending consideration before the Honorable Supreme Court. Full stop. Para. In view of the above, comma, the matter stands adjourned to be listed after 1 month.
1 month.
Full stop. In the
Maybe
meantime,
after 2
comma,
months,
the department may 2 months. In the meantime, comma, the department, the respondent authorities may finalize the process for release of the principal amount so far as WPC 2319 of 2017 is concerned. The Learned Counsel are also given liberty to make a mention of this matter in the event the issue regarding payment of interest is resolved in the Honorable Supreme Court.
Copy of the communication lot.
This one. We can make this a part of our record. Do you have extra copy?
That can be kept.
Yes, sir. The communication dated 30/11/2023 with regard to the steps taken for release of the principal amount is made part of the records of WPC 2319 of 2017.
Okay.
In respect of some dispute, my lord, this honorable court, my lord, directed the department to refer the matter to dispute review board. And accordingly, dispute review board has been constituted, and dispute review board, my lord, passed the order on 5/8/17, my lord. My lord, some claims were rejected, some were allowed, my lord. Then, my lord, as per the
Which department?
it is
Public Works.
Education and Public.
Public Works.
PWD. Education and PWD.
Yes. Now who will make the payment? Education, Mr. Gogoi.
2017, my lord, the order was passed, and as per a clause, my lord.
This is pending since 18.
18, my lord.
And he's a very limited prayer.
Yes.
That adjudication by the review board is not the subject matter of challenge.
No.
It has attained finality.
Final,
You
my
have to
lord.
comply with it.
Yes. At the time limit very fixed, my lord. And
You take instructions, when are you making the payment? Next, oh, we'll have it next Wednesday. Is it okay or next Thursday? We want to finish off this matter.
Next Thursday, my lord.
Next Thursday, is it okay for you, Mr.?
Yes.
Get a fish cool. Megman Lattu. Mohan Papa. Yes. Next Friday? It will be too late. So 18 matter. No. Okay, we'll give some time. Adi. Okay, we'll have it on 11th. 11th, enough time. Your name is not there. Okay. I heard Sri GN Sahalo, London Senior Counsel for the petitioner. Full stop. SC education is required. SC higher education, no? Also heard 3B Gogoi Learned Standing Counsel, PWD, who submits that the work was executed, that who submits that no doubt the work was executed by the Public Works Department, common. Such execution was done on behalf of the Higher Education Department, full stop para. Sri K. Gogoi, Learned Standing Council of Higher Education Department, who is present in the court, however, submits that some time may be granted to enable him to obtain the instructions, full stop para. He further submits that he was not aware of the matter as there was no proper reflection in the cost title regarding the department's involvement, full stop para. As agreed to by the Learned Council for the parties, list this case on 11/12/2023 by reflecting the names of SCPWD as well as SC Higher Education. But come up with the expectation that we're going to dispose of this matter.
18.
So today, what is
Lordship,
this?
this will perhaps take some time. The claim was rejected by the state level committee.
Can it be heard?
I am ready, Lordship.
No, not today. Pleadings are over.
No, pleadings are not over. They have not filed any.
Some instructions I have received that the parents short explanation.
19 matter, we grant you some short time.
After,
So actually, Lordship, what has happened, why the affidavit was not filed? The similar matters were there, I have taken instruction, the matters were there. And other matters were disposed of with the direction that takes because now what SLC already happened. So in their SLC, whether this matter was considered or not, I'm not aware, I could not get that. So I'll have to get their instruction. If I get some instruction, affidavit, otherwise I'll give it.
Okay.
So 2 weeks time.
Okay.
I'll just clarify whether
Okay.
it was
Okay. Sri A. Kolita Leonard, Standing Council, Industries and Commerce Department submits that instructions would be necessary, which are expected shortly, full stop. On his request, matter is adjourned to be listed after 2 weeks.
Item 19.
Lordship, similar pendency of SLP, only interest portion is.
It 19 भी वहाँ जाएगा.
payment.
Payment receipt, only interest portion is there.
19 list along with so and so, हाँ? वो पहला वाला. नहीं, एक ही ऑर्डर वो भी लगा दीजिए. सेम ऑर्डर. ये भी लगा दीजिए. अलग-अलग मत पड़िए, हाँ? इसको बता दीजिए.
22.
R. Chaudhary. Yes, we are about to raise Mr. Chakraborty. Why are you here waiting? Which matter?
Number 70.
70.
Supplementary. And in that case, my scenario is for the management.
So some 17B.
Yes, my lord.
Yes. 17B. Is he gainfully employed? Is he gainfully employed? No. You know the provisions of 17B, it's almost automatic unless you come up with the plea that he is gainfully employed. Is he gainfully employed? Are you gainfully employed?
No, my lord.
Have you filed the affidavit?
Yes.
And what is
And
it?
my lord, that plea was there in the written statement.
See, Mr. Dasgupta, if you stay an order, 17B automatically comes. Here, incidentally, or for what matter, we do not know 17B was not taken note of. Maybe by inadvertence. There is no requirement to hear you. It is up to him to file an affidavit that he is not gainfully employed. You can come up tomorrow that his affidavit is wrong, but can you object to 17B? You are in this field, you are a veteran in this field.
What this case is concerned, Lord, I have got.
No, on merit.
Tomorrow you are.
No, on merits, we are not having any dispute.
No, on merit, my lord, it appears that he is gainfully.
We are not, it depends on his affidavit. What is the requirement in law? You know better. He has to file an affidavit that I'm not gainfully
I know
employed.
better, that is why I would like to test.
No, is there a requirement to hear you? No, in applying 17B?
Yes, Lord.
Or is it
If-
the,
if
is
I
it the,
can
is it the
if I-
responsibility of the
if I
workman?
can come with a case that he is again for you, that could be.
Then we'll recall the order. 17B is a matter of right. After workman dismissed, how can he survive?
I know very well all these things, sir. Not
Then-
unknown, but a new thing, Lord. The so far my case is concerned, I have to argue.
No, was 17B refused?
Only yes.
It was not even taken into consideration.
Only yes, not the file is a
No, normal matters will give you a hearing, but here it's a matter of right that when you move the matter,
Take it tomorrow.
tomorrow,
No,
not tomorrow, tomorrow we may not come to the
I
court.
have an instruction in that. That is why.
Where is the order of admission?
It is 1810.
So
Rule has been issued.
No.
On
No,
1810/23.
Order to. Okay, file to.
1810, this case rule. has been-
Except penalty.
The reference was for termination or what?
Yes.
Termination?
Yes.
Reinstatement allowed?
Yes.
Mr. Dasgupta?
No, but that's not the case. But one day can may kindly be.
That is, that's not the case.
Or let me argue this fact.
We'll hear on merits if that's not the case.
Yes.
17B, how can you refuse 17B?
Yes, I can.
You should have
refuse it.
pointed out to the
Because
court.
The case is that it was against me employer, but the case that one day you will come, give it over us. And that is this fact.
Where is your affidavit?
My lord, may I have a look at page 63?
No,
That is-
your affidavit in the I. Where is the statement?
No.
And the I.
Paragraph, page number 4, paragraph 6. My lord,
One day, tomorrow you have to take it.
Sorry.
Take the one more.
17B, sorry.
So that's why I know 17. I have conducted this for last 30 years.
You come up with an application that is gainfully employed. Now we don't need anything except his affidavit now. Order was passed when?
my lord, stay order on 1810/23. This is the first of motion. that-
18/10/23. Okay, well, Monday we'll have it.
Monday,
Tomorrow I can.
tomorrow, Saturday.
Sorry.
My lord,
No, your loss is very much worried about it. So as if he will be. That is why.
Dismissed employee.
my lord, instead of.
Award is of which date?
My lord, award is of 21/7/23.
His case is a very, very serious case. On me, time me.
Mr.
I
Dasgupta,
can order your lordship
Mr.
to-
Dasgupta, we may have to ultimately allow your petition. That's a different matter.
No,
But
no,
the
that
statute, the requirement of the
itself will
statute,
indicate that
if
he
an
is-
award having a dismissal, reinstatement
All right,
is stayed,
Monday.
17B
My lord,
has to
instead
be.
of Monday, can it be on Tuesday, my lord? Because Monday I'll be out of station.
So let it be on 8.
8 next Friday. We do not know what is going to happen on next Friday. Okay, and 8th. Okay, heard. 3. S. Chakraborty, learned counsel for the applicant who has filed this application for invoking the provisions of Section 17B, capital B, of the Industrial Disputes Act 1947. Full stop. it is contended that the writ petition pertains to a challenge to an award dated 21/7/2023 passed by the learned Labour Court, Kamrup, Labour Court Assam, Kamrup in, is it not a reference case?
My lord, my lord.
2A. Oh, in a case-
Conciliation initiated but not referred, that is why he directly approached.
It doesn't matter. 2A is available termination.
Yeah.
And case under case in case number 2/2022, which was adjudicated under section 2 capital A of the ID Act.
Section 2 of Cartel Prayer.
It is submitted that while a rule was issued by this court on 18/10/2023, the provisions of section 17B was not taken recourse to. Full stop. Sri Chakraborty has also referred to the averments made in paragraph 4 of the IA, where he has stated in affidavit that during the time of the proceeding before the learned Labour Court, he was not gainfully employed, and neither, and even as on today, he is not gainfully employed, and therefore entitled to the benefits of provisions of section 17B of the Act. Full stop. Para. 3. Dasgupta, learned senior counsel for the opposite party writ petitioner, however, submits that he may be given time to file objection. Full stop. Para. This court is, however, of the opinion that such objection is not a requirement of law, inasmuch as 17B, the application of 17B is dependent upon a statement made on oath by the workman regarding his lack of gainful employment, and the same pertains to certain cases which falls under, and which pertains to certain circumstances, and termination from service is one of such circumstances. Full stop. Para. Be that as it may, in the interest of justice, the matter is adjourned to give the opposite party writ petitioner an opportunity, and the same be listed for orders on 8th. Okay, rest dates will be given.
My item number 39 may be fixed on Tuesday, my lord.
Dates he'll give. Any matters where interim order is till today?
Tuesday, my 7, my lord. Item number 66, my lord.
Interim is till today.
There is an interim matter, my lord. My lord, only my lord, matter may fix after 15, my lord. My lord,
He'll give dates.
senior
Interim in item number?
Item number 66, my lord.
66 interim, huh? Date.
My lord,
57 also interim days.
Any matters interim?
27, 28, 29.
Interim is there?
Interim.
27, 28, 29. Get the dates, Mr. Dihinga, get the dates and.
Lord, my lord. Obliged.